Only 3 matters, similar matters are pending.
And
Second, next is other dispute.
Kuntu. Pardon to mention, your lordship, old matter 2010, your lordship, the petitioner is suffering various diseases. And candidate admission. You also kindly taken next week ending that.
सेमती कहबो दियो जे देखिया
Second
admission.
Fresh admission.
yes
Part 19,
one memo return one other memo
Executive court going
only one memo you decide which one to
Lordship, pardon to mention. Lordship, pardon to mention. Fresh admission. The appellate court remit back the case to consider the same.
dion
Anganwadi.
Due to interim stay, the wife is not getting alimony.
beg pardon. Madam, part third matter of 2016. It was before Lordship on 16/8. Your Lordship had the matter, fix it to 23rd of August. Though in this page of the website shows the date has been fixed to 23rd of August. But the order sheet inadvertently it has been mentioned as 23rd of September. That is the reason the matter didn't appear on 23rd August. So now my lord.
yes so yes
Oh, blessed.
Supplementary item number 1, fresh admission.
yes item
Item 28. I have received a telephonic call from the concerned advocate to be appearing for the petition. He is not well. Any
item 28 next week as well
Pardon, my lord. Item number 29, discussing the possibility of mediation.
29 place this matter 2 weeks after date for
19th September.
19th September
Right, number 1.
item number yes
May I please, Lordship. Now, here the petitioner seeking transfer of the 125 case from the learned judge Family Court Jaspur to learned court judge Family Court Dhenganal Miller.
all right notice stay date for
Grateful, my lord.
date
24th October.
24th October
Grateful.
Item number 2,
Not urgent certified copy.
urgent copy
Grateful.
yes item 2
Yes, ma'am. Seeking transfer of the DV proceeding pending with SDGM Burger to SDGM Noapada. That proceeding under Annex 1, page 8, proceeding under that 512 and section 7.
why what is the reason
No, petition in fact is a 2016 marriage, 17 blessed with a male child. From the day one, she is
so why do you want the case to be transferred
170 kilometers. I am suffering from
so what
serious ailment.
so what will happen to the lady what will happen to the lady
From the marriage itself, from the inception, she is staying in her parents' house.
How I can permit you to appear through virtual mode if you so desire, but
As yours.
if you can show me good reason, I will transfer it. It's not as if a husband instance transfer only, semti kotha nahi. But normally the wife's convenience has to be
So
seen.
that is the paramount consideration.
So naturally, how will the lady not find it difficult to travel to 170 kilometers?
In fact, from the day one itself, she is
The
staying.
petitioner,
May I pay? Let's keep it next week. I'll write one. Next week.
my mind will change.
No.
Then
He'll also say that.
so
this-
order will
He also say VC that.
yes. No, you can do one thing. You can seek withdrawal with liberty to approach the court below to appear through virtual mode.
Also observe that one. Because he is suffering
Then
from
transfer
some
to the-
element. He is not in a position to whack off his
Transfer
own
for the
without
petitioner
the
seeks
assistance of
permission
others.
to withdraw the transfer application with liberty to approach the court below for permission to appear through virtual mode. Stop. Permission is granted with liberty as aforesaid. Further, the court below, while dealing with the application for appearing through virtual mode, shall take into consideration the fact that the petitioner is ailing. That's all.
item number 3,
In support of the same, I will file some.
You will file that.
Yes.
I have only made
Yes,
an
sir.
observation, it will help you.
Yes, sir.
Item 3.
May I please, Lord? Sir, the petition seeks for a direction for transfer of CP case number 727 of 2022 filed before Family Judge Cuttack to the London Civil Judge Senior Division Athagad. The petition is a poor lady, my lord.
Notice, stay. 24th October.
item number 4, may I please?
In this case, the petitioner wants to transfer the case CP number 858 of 2023 from the Judge Family Court Cuttack to Family Court Jaspur.
All right, notice, stay 24th October.
Item number 5,
May I please, your lordship. My lord,
Transfer application from the civil judge senior division Khalikot to civil family court Kotak
All
matter.
right, notice, stay 24th October.
Copy urgent copy.
Name yours.
Yes,
In the North case of petition in that 52 Sikhas Act, they highly depend upon regulation. Thereafter, the secretary rejected, then file appeal for the honorable minister. Being not considered, this honorable High Court directed to consider the appeal within limited time. Then honorable minister, hearing from both sides, pass an order, final order.
where is that
Thereafter,
order?
my lord,
Where is that order?
that is the order of the honorable minister.
89.
That is running page
89.
running page 17,
Sir, please tell me the annexure.
annexure 17, my appeal, that is running page 120, 120. And both the parties, Lord M. Pratap advocate for the appeared for the appellant and director of education and other officer appeared from the opposite parties. Act to the not given below to come into the conclusion in the ends of justice.
No, what is your grievance actually?
My grievance, then after this order passed by the governor minister, then fresh notice for re-hearing the same appeal was issued, which your lordship in this court state being functus officio. After that, my lord, the government file a counter with a affidavit. The review is pending some by the director. So, as your lordship knows, as the Supreme Court judgment, in a region given the counter affidavit can never read with the original order. That is the Supreme Court judgment. That is MS Gill Mallard.
Just.
Without considering the submission.
What happened to that other writ application? Where that notice was stayed? What happened?
That order was when in that case government filed a counter affidavit with the reason the one review is filed by the director office. That office, I submitted that review can never be accepted as rectify the bona fide mistake in the original order notice for re-hearing. But however, without go and approach the honorable minister, the honorable minister will issue fresh notice. No notice issued. One notice issued before the election. After election, no notice. But that secretary Mallards rejected the total order passed by honorable minister Mallard.
You take notice. Take notice. Learned AG accepts notice on behalf of all the opposite parties. Let a counter affidavit be filed. Answering the averments of the writ application within 4 weeks. Does this matter?
24th October.
Huh?
24th October.
On 24th October. IA. Operation of order dated 2/7/2024. Passed by the Commissioner cum Secretary. School and Mass Education Department. In respect of the petitioner shall remain state till the next date.
Item number 7. One submission. Next.
Item
Item 8 was same.
Item 8.
Next one.
Item 8 is same.
Item number 7.
May I please? Sir, my lord, the annex of 4 is under challenge, wherein the candidature of the petitioner for the post of Anganwadi worker has been rejected by the opposite party number 5, which is not only beyond the guideline, but also on misconception. But the guideline says on the date of physical verification, the CDPO has to publish the merit list, but it was published beyond 4 days. Apart from that, my lord, the Lakshmi kindly peruse annexure 4, that is the list published on the date of verification of the original documents. The page 21, Lakshmi kindly peruse, serial number 10, the name of the petitioner is there. In the remarks column, it is stated +2 mark sheet dakhala karinathibha hetu nakocha karala. It was deposited on the physical verification date, my lord. And apart from that, it was deposited in the online application while submitting the online app. Annexure 3 is there. Annexure 3, it is clearly mentioned that intermediate page 19, page 19. The online registration. Last portion, serial number 2, intermediate Salepur Higher Secondary School 2021, it is attached. They say that technically difficulty jogu seta upload ହେଇ ପାରିଲାନି.
So anybody has been appointed in the meantime?
No,
Nobody has been
no,
appointed.
no.
He can file an appeal probably.
Yes,
He can file an appeal before the sub-collector or the ADM.
for the ADM.
Since selection has not been made, so I cannot prefer appeal. After selection, I can challenge the selection. In the meantime, selection has not been made.
Yes, what do you say then? Take instruction.
Your lordship would.
It is submitted by Sri A.K. Pandal and comes to the petitioner that his client's candidature was rejected erroneously on the ground of non-submission of the +2 certificate,
Plus,
even though the copy of the same was uploaded along with the online application form, and further, the original was produced before the selection committee.
yes.
Stop. He further submits that no, this selection proceeding has not been finalized as yet.
Yes.
In such view of the matter, the State Council is directed to take appropriate instructions in this regard to apprise the court appropriately. All the persons who have made parties,
Yes.
not necessary, will not issue notice now. Let him obtain instructions.
Till then, the final selection.
Aye. In the as an interim measure, you're looking to list this matter on
19th September.
19th September. Till the it is as an interim measure, it is directed that the final selection of Anganwadi workers of Gopinathpur to Anganwadi Center. Final what is to cut it out. Selection of Anganwadi workers shall not be finalized till the next date, comma, if not already finalized in the meantime.
Yes.
Obliged. Only your lordship may say pursuant to Annexure 1, Gopinathpur Anganwadi Center pursuant to Annexure 1.
Pursuant to Annexure 1.
Because 6 numbers of Anganwadi.
Item number 9, pattern matters.
This was hard in part last occasion.
Yes.
Your lordship wanted to, from the state council to take instruction. Of course, your lordship have not indicated in the order I found. On the basis of the additional affidavit which I filed, I have enclosed the copy of the resolution of the state government, where
What is this matter?
I'm just thinking. I've given a date chart to also can't see that. A school which was established way back in 1989 and the petitioners having requisite qualification, they were appointed in their schools. And at that time, there was a proposal the school should be taken over by the government because
So this is the taking over.
yes. And there are 2 judgments in the meantime. That judgment also is the
Relating to some other school.
some others.
Sir, Brajaraj
Yes. You also rightly remembered. And one case also in the Supreme Court, they said that. So now I produced another resolution of the government dated 22nd April 1997, where government as a policy matter decided that all primary schools should be taken. That you also kindly see.
Yes.
I have enclosed along with my additional affidavit dated 29/7/2024.
No, your resolution is 22nd April 1997.
Yes, that is exactly that.
Yes.
I'm just reading that. Taking over the management of Sisu Science. So that is in respect of another, but this is where they have said like this. The new policy, educational policy has laid stress on the universalization of primary education. As the primary teacher laid the foundation of the education, there is justification for improvement of their service condition. Accordingly, government have declared all the primary schools in the teachers, primary school teachers of the school, managed by Panchayat Samiti, non-government primary school, as well as urban local body, and the schools directly administered by the district inspector of school and the assistant teacher, headmaster, and mistress of government servant with effect from 5th September 1999. In order to bring an uniform system in the primary education of the state government decided to take over the management of the primary schools established by volunteer agencies and other non-government organizations and imparting the same education as per the syllabus of the school, keeping in view about the principle of the This decision, your lordship wanted to know from Mr. Das that if you have taken such a decision for universalization of all primary schools, why not that will be applied to the
Yes.
petitions?
The counter says that it is not possible because it involves huge finance.
No, but it is after filing of the counter, he has brought to the notice.
Yes.
You have not answered this. You are required to give a specific answer whether you want to follow this 22nd April 1997. If not, then why not?
কপি দিয়েছি না affidavit দিয়েছি না কপি
But affidavit file is,
দিয়েছি না
it's on record. Annexure,
তারপর
sir, annexure, yes.
ଆଉ ତାଛଡା ଜଜମେଣ୍ଟ ତିନିଟା ଜଜମେଣ୍ଟ ଦେଇଛି ଜଜମେଣ୍ଟର
Other division bench judgment of this honorable court says that you cannot seek for mandamus.
That is one part. Probably they have not considered the effect of this resolution. I don't know. Whether this resolution has been taken note of by the division bench.
No, that is a different.
That of course I don't find.
That is totally different case.
So here you have to, the state has to, Mr. Das, the state has to respond to this particular, I can grant you only 1 week time.
Sir,
Heard further arguments in part. Sri A.R. Das, learned AGA, requests for further time to respond to the contentions of the petitioners as per the affidavit filed on 29/7/2024, enclosing therewith copy of resolution dated 22/4/1997, which lays down the policy of the government to take over the primary school teachers of all schools of the state. All primary schools of the state. So, let an affidavit in response be filed by the state within a week. Let this matter tapar go to tapar week.
12th September.
On 12th September.
sir,
Item number 10.
Item number 10. Lordship on 8/8/2024, your Lordship directed state to obtain instruction, your Lordship. On the issue, however, the order query of the court as to whether the petitioner was considered in the general.
It was said that the affidavit with all the annexures filed with the state be filed again.
Lordship,
The annexures were not tagged, that is why.
they have filed the,
Have they filed that affidavit?
Lordship, they have.
Mr. Patnaik was dealing with.
They have filed, but they are not touching the point which your lordship have been raising every time in different orders. What your lordship, let's say, what your lordship is asking, referring to the government in our petition, kindly see order dated 8th of August 2020.
Yes.
But they are not making that position clear at all.
Whatever.
They are trying to avoid that issue.
All right.
Now, the point before my lord says, altogether, 8 persons were called for certificate verification. Posts were 5. Right, my lord? Now, the 5 persons who have been appointed, they have never appeared for certificate verification. That is what a point taken on affidavit, which your lordship has been asking them that file an affidavit justifying whether they have appeared for verification. If they have appeared for verification, they have admitted they have not appeared. So if they have not appeared for verification, they could not have been appointed. So it's I think should not be said. They have in fact placed people of their own choice in place of these vacancies by giving appointment to the non-existing people, those who have not appeared. And now trying to avoid this issue somehow or other, playing.
Yeah, but has the affidavit with all the annexures been to whatever, what will accept that affidavit? It is at their risk. Whatever they filed, if they have not answered, they have not answered. It is up to them.
Yes, ma'am.
So the consequence will follow.
Yes.
Yes, Mr. Das. Yeah, but whether that affidavit with all annexures have been filed again, that was the direction. Mr. Patnaik was conducting the case.
with all humility, may I submit the file is not supplied to the. Tomorrow you will.
Tomorrow, sermon nahi.
Day after tomorrow.
Shanivar court.
Day after. Let's this matter day after tomorrow as requested by Lance. Sombar koriyo. Sombar hele again it will disturb the apple cart. It will upset the apple cart because I have other matters. I have fixed it. So
Shanivar koriyo.
ଶନିବାର କରିବା କଣ ସକାଳ ବେଳି କରିଦେବା ଘଣ୍ଟାଟେ ଖଣ୍ଡେ କରିବା କଣ ଶନିବାର କଣ ହୁଏ ଆପଣ ଜାଣିନାହାନ୍ତି ନା ତଥାପି ମୁଁ ବସିଛି ବେଲ ଫେଲ ହେଇଥିଲେ ପୁରା ବସିଯାଇଥାନ୍ତେ ବେଲ ତ ନାହିଁ ଯେତିକି ବସିବା ବସିବା
ଶନିବାର ଆମ ମାଇଣ୍ଡ ସେଟ ହଉଛି ଛୁଟି
ଦେଖିବା let this be regularized then we can take it we may not hear it finally on that day but let this thing be regularized. Yes,
After lunch should not before lunch.
Item number 11.
Please, your Lordship. At the occasion, your Lordship had directed the Learned State Council to take instruction on the harmonious reading of
clause 1 and clause 4 would like this specific response of the state in this regard. Clause 1 and 4 of the revised guidelines. Yes.
Same difficulty, sir.
File is not there.
No.
All day after tomorrow. Please this matter day after tomorrow as well.
Item number 12,
Pass over.
item number 13,
Your lordships, in last order dated 22/7/2024. Directed to files.
Where is the RTA application? कौन जଣା पड़ुଛି?
Appointment pending.
Yes, yes.
ସ୍ୱର୍ଣ୍ଣଲତା ସହାୟକ ନିଯୁକ୍ତି ଦେଇଥିବା ଶିକ୍ଷାଗତ ଯୋଗ୍ୟତା ଯାହାକି ଅତ୍ର କାର୍ଯ୍ୟାଳୟ ଉପଲବ୍ଧ ନାହିଁ।
So why was this direction issued?
Because in paragraph 9. Local standing of the.
Let us go to paragraph 9. Paragraph 9 of the counter. Counter filed by
the private opposition.
private opposite party. Private opposite party counter कहीं? Your opposite party number?
5 and 6.
5 and 6. Nothing. Counter 9.
4 and 5.
4 and 5. Okay. Paragraph 9, na? So this proves that she was appointed.
She was appointed that admitted.
Yes.
But here is question that has been violates the guideline as per accordingly the appointment has been set aside by the appellate authority. Kindly have a glance to the order passed by the appellate authority by the annexer. Annexer 5 of the writ application, page 15. The petitioner Sandhya Jana and another have filed an Anganwadi appeal bearing number 2 of 20 challenging the order dated 21/3/2000 CDP derivation regarding appointment of Sonalata Sone respondent Anganwadi Danpur Anganwadi. The petitioner has filed the WPC number so and so where the Honorable High Court by order dated Director ADM Kendrapada to dispose of the Anganwadi. In this context, the parties are duly noticed and a report of the call from CDP derivative. It is ascertained from the petition that Gitanjali Janna and Sonalata Sorangi were working as Anganwadi worker, Anganwadi helper, respectively in Anganwadi center of village Danpur consist of ward number 6, 7 and 8. And they are the inhabitants of ward number 6 and 7 in the said village and performing their duties. Due to the sad demise of Gitanjali Janna, the Danpur Anganwadi center on 3rd Solo, there was a casual vacancy of Anganwadi worker post and the AH Sonalata Sorangi, the present petitioner of the said AW has been promoted to the post of the petitioner have alleged that without following government guidelines, the post of Anganwadi Danpur is filled up without adhering government. Had the file written notes on rules upon Sonalata Sorangi Danpur Anganwadi willfully placed the existing vacancy for which petitioners are deprived being aggrieved approached this on the opposite party being the inhabitants or ward number 8 is not entitled to work at Anganwadi. He is admittedly the petitioner.
Complete.
Ward number is not entitled to work as Anganwadi worker in ward number 6 and 7. Further, no advertised notification has been made for appointment of the Anganwadi worker for the said Anganwadi center and ignoring the procedure laid down in the guideline of government Sri Sonalata Sorangi, he said has been promoted to the post of Anganwadi worker. It is also stated that petition Anganwadi namely Danpur Anganwadi created in the year 2000 taking into service area of 6 and 7 and 8 Danpur GP and Srimati Gitanjali the inhabitants ward numbers appointment of the Anganwadi worker and Sonalata Sorangi inhabitant ward number 8 as Anganwadi helper. Subsequently, during year 2010, the Anganwadi center has bifurcated. New center was created, ward number 8 as Danpur Co. and Srimati Damanti Jana and Annapurna were duly appointed. Accordingly, original Danpur Anganwadi center exists, taking into service area of ward number 6 and 7. It is further alleged that Srimati Swarnalata Sarangi, the Anganwadi helper, promoted to the Anganwadi worker in the inhabitant ward number 8, but engaged and Danpur Anganwadi service area consistent ward number 6 and which deviates the guideline, since the government guidelines provides that the Anganwadi worker and Anganwadi helper should be the inhabitant of service area of the concerned Anganwadi center. The petitioner have challenged the engagement and pray to reject the illegal order of appointment. In this regard, the factual report has been called for. This is vital. Called from CDPO derivation and same received and attached by the office which forms the part of the case record. CDPO concerned stated that this type of cases there is no need of fresh notification as required except the willingness of the Anganwadi helper of the concerned Anganwadi center. If the Anganwadi helper having HSC qualification passed in your favor have worked for more than 5 years in the same Anganwadi center, she shall be selected as Anganwadi worker in the respondent number 1 as Anganwadi worker in Danpur Anganwadi center. According to the government guidelines, there is no irregularity has been made. The proceeding of the selection committee annexed from the Swarnalata Sarangi Anganwadi helper from the Danpur Anganwadi center as per guidelines. She is eligible to observe after proper verification documents in her favor by the committee. She is selected Anganwadi of Danpur. On perusal of the letter numbers 2007 issued by the WNCD department regarding the revised guideline selection of Anganwadi worker in connection with Anganwadi helper in paragraph 4, it appears that helper and Anganwadi and organizer, if having the requisite qualification are found to be suitable, shall be selected Anganwadi worker, provided they have worked more than 5 years. Regarding the procedure of engagement, the casual vacancies of new Anganwadi notification regarding the Anganwadi center where the Anganwadi worker is going to be engaged will put up simultaneously in the village, in the concerned GP, Panchayat Samiti and CDP office. Thereafter procedure shall be followed. But in the instant procedure has not been followed duly, followed by the government guidelines and notification has not been issued accordingly. It is crystal clear that views of the CDPO database as per report contradicts the guidelines of the government. This is open deviation of the revised guideline issued by the Welfare and CD Department, Government of Orissa on the above observed considered documents material.
All right. Yes, so Mr. Naik, how do you justify?
Sir,
It was never notified. It was never made known to the public at large, and no selection process was initiated. All that the guidelines prima facie indicate is that you have to get preference for having worked as a Anganwadi helper.
not preference because he is a Anganwadi helper. When the Anganwadi worker post of Anganwadi worker was vacant, then he joined as a Anganwadi worker.
She cannot.
He selected as a
Selected by? Was there any selection process?
No.
Was there any notification?
Admittedly, my lord.
So
That is admitted.
that is the problem. That is the problem.
Another point is that, my lord, in the
Just
year
a moment,
2018, my lord, the petitioner appointed.
It only says Anganwadi helper and organizer if having the requisite qualification and are found to be suitable
And having worked for 5 years.
ତାପରେ ଅଛି shall be selected as Anganwadi worker provided they have worked for more than 5 years. So this word, use of the word and means that you have to be found suitable. Found suitable expression, what does it mean? Suitable in a selection process, in a suitability test. You cannot straight away there. Otherwise, it would have been simply a case of promotion.
My lord, in rule 4, my lord.
Yes, clause 4.
Clause 4, sorry. Anganwadi helper and organizer, if having requisite qualifications and are found to be suitable, shall be selected as a Anganwadi.
So there has to be suitability. There has to be a test of suitability. The CDPO by himself or herself cannot decide that this person is suitable. Suitable means as compared to others. So when you have to compare a person with others, necessarily there has to be a public advertisement or public notification. It has to go to the Mahila Sabha or the Grama Sabha, whatever. It has to go.
But they have not loco standi, my lord.
They may not have local standing. They may not have local standing. See, you have come to this forum.
And on the application on the
True. This order is against you. That is why you have challenged that order.
Right.
The question of locus standi.
locus
see.
standi and limitation. Because
limitation?
after 2 years of joining as a Anganwadi worker,
No, they had come to this court probably earlier. Yes.
no, earlier they have filed an application.
No, the date chart. Date chart to karibeni janibe kinti hum. Where is your date chart? Mr. Naik? Where is your date chart? What is this? Why are you not ready with the date chart? How will this sequence of events start? When were you appointed, sir?
My lord, in the year 2018, madam.
Anganwadi helper. All right. So when was this casual vacancy? When did that vacancy arise?
2018.
On the same 2018.
My lord, in the year 2018.
And you were engaged as Anganwadi helper when?
Helper 2001.
2001. So you have the 5 years experience.
Right.
More than 5 years.
Right.
In 2018, there was a vacancy. You were appointed as
18.
Anganwadi helper. All right. So when did you challenge?
In different Anganwadi center. That is not when in
True. Let us admit that it is completely illegal. But when did you challenge?
I challenged in the year 2020 before this honorable court challenging the
By these 2 years?
after obtaining the certified copy. I am aspirant when the notification shall be made. Thereafter, I have to obtain the certified RTA Act, the information RTA Act. Thereafter, I prefer.
When did you obtain that certificate? Under the RTA Act?
RTA Act I obtained 18. So 27 2018.
Yes, 27/8/2018.
18.
So,
Thereafter, I approached before the authority.
yes.
But no result has been there. For which I filed the writ application in the year 2020. And Honorable High Court directed to file appeal before the appellate authority challenging the appointment. Thereafter, this thing has been.
So now you have to satisfy the court what locus standi you have, and again, as he has pointed out, what did you do for since 2018 to 2020? Could be it is a question, yes, that there may have been some illegality or irregularity of procedure, but all illegality cannot be cured unless you come in time. Yes, Mr. Das, what is your stand?
Our stand is,
You have not filed a counter.
no counter has been filed. Instruction is that rule has been given to us, that's all.
What has been given?
That rule of 2007.
That
It
is the
says
instruction.
about the helper, how it, as your lordship also read out.
No. I would like to know, as Mr. Naik has raised 2 points.
Sir.
One is the limitation. Limitation means unreasonable delay. When you allow somebody to work for 2 years and thereafter question his appointment, it becomes a little bit difficult. Secondly, they were, what is the locus standi? They were never applicants. Locus standi I am willing to accept. Locus standi I am willing to accept. They will be affected because
Other
it
aspect.
was never notified, so they may be affected. But what about the delay part?
There is no scope to know this appointment has been done in the year 2018.
So that is what I am saying. I am taking this 2018.
Yes.
So 2018 immediately you did not do anything after receiving this information. You received it in 2018. 27/8/2018 ରେ।
27/8/2018
ଆପଣ ରହିଗଲେ ଚୁପ୍ ରହିଗଲେ।
ଚୁପ୍ ରହିଗଲୁ ତାପରେ ଆମେ ଆପ୍ରୋଚ କରିଛୁ ଅଥରିଟି
ସେଗୁଡାକ ମାନେ କିଛି ଥାଏ ସେ ଆପ୍ରୋଚ କାଇଁ ଗୋଟିଏ ଖଣ୍ଡିଏ ରିପ୍ରେଜେଣ୍ଟେସନ ଦେଖେଇଲେ
ରିପ୍ରେଜେଣ୍ଟେସନ
ତିଆରି କରା ନୁହେଁ
ନାଇଁ
ତିଆରି କରା
ରିଟ୍ରେ ଆମେ ଦେଇଛୁ ଆଗର ଯୋଉ ପ୍ରଥମେ ଯୋଉ ରିଟ୍ଟା ଅନରେବଲ କୋର୍ଟଙ୍କ ପାଖରେ କରିଥିଲୁ ସେଇ ରିଟ୍ରେ ହ୍ୱାଟ ଏଭର ଡକୁମେଣ୍ଟ ଆମେ ଦେଇଥିଲୁ ରିପ୍ରେଜେଣ୍ଟେଟିଭ
difficult. Some irregularity of procedure may have been there, but you cannot say that she is not eligible or qualified. She has the qualification. Since 2001, she was working as a helper. Yes, please satisfy the court on the delay as well as the what do you say, locus standi.
Locus standi, because I preferred appeal. And
no, you preferred appeal, but whether you could have preferred appeal.
I preferred honorable.
Where is the order? Where is the other? Case?
I preferred appeal. I preferred writ application before the honorable.
All right. List this matter day after tomorrow along with the WPC. What is that previous number?
Those.
ये ऑर्डर तो लिखा ही तो होगा। हाँ, WPC number 15586 of 2022. हाँ, this matter day after tomorrow along with the WPC number. आज एक लिखूँ तू, अगर प्रथम लिखूँ तू, counsel for the private opposite parties files an additional affidavit. Have you served copy?
Yes.
After serving copy on the other side, same be kept on record. Therefore, list this matter on day after tomorrow with along with WPC numbers.
Item number 14.
Pass over.
Item number 15.
Number 15 the washing machine, no instruction.
No instruction dispose of.
Item number 16.
Pass over.
Item number
Hon'Ble Mr. Dhara, this kind of listing.
Item 16.
Again.
The 2011 matter.
Opposite party.
No. Let the petitioner come. Let the petitioner come. Yes.
Item number 17.
Yes, item 17.
Madam, on the last occasion, there was a direction by the collector to conduct an inquiry after giving sufficient opportunity to the respective parties to be heard. And on the last occasion, madam, in the month of July, when this matter was taken up, I had mentioned that, madam, that they had not.
Inquiry had not
completed
been
this.
concluded.
So, my lord, they have sent me a letter, my lord, on 3/8, my lord, that they need 1 month time. So, my lord, this matter may be taken up in the month of last week of September. So that by the time, in the meantime, my lord, the collector has been changed.
As required.
The lawsuit were directed since April. April again, 4 months already.
Second week of September, no?
Second week of September, sir.
Then State Council submits that as per instructions received on 3/8/2024, the inquiry, which is going on,
Yes.
is likely to be concluded
Yes.
by the first week of September. Place this matter on
12th September.
12th September. It is clear that no further time shall be granted.
Three copy of this.
Three copy of this order be handed over to the London State Council for compliance.
Most of it.
Item number 18.
Rejoinder my lord, copies of government as well as the private.
You received copy. You can take up
I have received the copy today.
today.
Right.
Are you are ready?
No, my counter copy, your lordship has directed last week, but I have not received.
Counter of the state. All right. Learned counsel of the petitioner files rejoinder the court after serving copy on the other side. Let a copy of the counter filed by the state be served upon the private opposite party.
7. 57.
Does this matter next week or go? Next week only. Please this matter next week.
Item number 19.
Item 19, I prefer a passover, madam.
Pass on.
19, my lord, I have last week appeared for the OP number 4. 2 weeks time to file counter.
Sri D.K. Pani, learned counsel appearing for the opposite party number 4 seeks 2 weeks time to file counter. Let's this matter
26 September.
Huh?
26.
on 26 September. Counter if any be filed in the meantime.
Item number 20.
Passover, lordship. Senator proper to this matter, lordship.
Ask him. Other side is also a senior counsel. Ask him to come.
Another code, lordship.
It's all right. All right. Sir, pass it over for some time.
Yes, 2
Pass
Passover.
over. Inform him.
Yes, sir.
Item 21.
One pass.
Pass over. Look into. All right. Pass over.
Item 22.
Wait.
Yes, item 22.
My lord, in this case, on the last occasion, I was directed to submit the information and affidavit, particularly indicating the fact that at the time of disengaging the petitioner, whether collector has actually granted him the reasonable opportunity.
There is no such order.
A connected case order has been passed.
There are two cases. my lord.
991.
Oh, 991 is as well.
One case is, my lord, with respect to regularization of the maternity leave period. That we have already done it, my lord.
Just. See, let me just see the order.
Yes.
Order dated 5.
The State Council draws attention of the she has not granted an opportunity of hearing with the collector before passing the government's made in paragraph 7, to satisfy the court. If the petitioner was granted opportunity of hearing before passing of the impute order.
So, my lord, we have already filed an additional affidavit to e-filing. I am submitting the same, my lord. Hard copy the.
Dita ko?
submitting.
अच्छा,
Dita case mein
data case for me.
ଗୋଟେ case କହିଛୁ ଯେ ଆରୋକେ ମାନେ the prayer of the petition has already been infructuous with respect to the medical leave. And in the second counter, my lord, that is in 9991 of 2020, lordship may come to para number 9 of our application.
कोथरे?
ये जो 9991 of 2020. Additional affidavit of para number 9.
Yes.
My lord, that with reference to the issue so far as the granting opportunity of personal hearing before passing the final order by the collector CEO, Jilla Parishad Navranpur, there is no evidence to that effect.
So we'll have to set aside and remove, remit him back
To
for.
take fresh decision, my lord, after giving up reasonable.
So this is 9991.
My lord, yes, my lord.
The other case according to you has become infructuous.
He will also,
Then we'll simply dispose of as infructuous.
yes, ma'am. Because the
8180.
has already been credited to the account.
He's accepting it. It is submitted by the parties that the relief claimed in the writ application has already been granted by the opposite party. Hence the writ application has become infructuous and is disposed of as such in 9991 of 2022. As directed, the State Council has filed an additional counter affidavit after serving copy on the other side.
Para number 9.
In the said affidavit, it is stated under paragraph 9 as follows. Stop. This is a clear admission regarding non-grant of opportunity of hearing to the petitioner before passing of the impugned order
By the collector.
by the collector come CEO Jilla Parishad Navranpur. Such being the factual scenario, such being the fact, the impugned order naturally becomes unsustainable in the eye of law for being passed in violation of the principles of natural justice. The writ application is therefore allowed. The impugned order under annexure 9. 9.
Yes, ma'am.
Is hereby quashed. The matter is remitted to the collector Navranpur for deciding the same afresh after granting proper opportunity of hearing to the petitioner. Stop. To the petitioner and by passing a reasoned order within
1 month.
within 1 month.
Yes.
From today. Yes. Writ application is disposed of accordingly.
Yes.
Item 23.
Prefer pass over your lordship.
That's all.
Item 24.
My lord, in item now 24, we have received a parawise comment on.
Yeah, we'll have to wait because the petitioner is not there.
I am for the petition.
Oh, you are it?
My lord, on behalf of Mr. Pradhan.
No, what Pradhan? Please, Vrindavan Rao.
My lord, from Brindavan Raut.
I mean, nije janne dikha abhi.
No, Brindavan is the title.
My lord, on 27/8, my lord, I have received a parawise comment. My lord.
Now, according to both the titles are same. এখন ଆପଣ ସାମ୍ନାରେ ସେ ଜାଗାଟା କହିବେ ଆପଣ ଏପଟକୁ ପଳେଇ ଆସନ୍ତୁ ହଁ ଠିକ ଅଛି ଆମେ ସେଇ ଜାଗା
Counter not received.
I have received a parawise comment on 27/8, my lord. This is 2024, my lord.
ଆରଥର ବି ସେ କଥା କହିଥିଲେ ଆପଣ 8/8 ରୁ ସେ କହିଥିଲେ that he received the parawise comments and request for some time to file counter.
But that parawise comment, my lord, I have received only on 27/8, my lord.
No, but on 8/8/2024 I passed this order.
Sorry.
I could not have passed this order in anticipation that you will say this. Obviously. I'll grant you, by next week you file your counter.
Yes, ma'am.
Let's this matter next week. Counter by state be filed positively. After serving copy on the other side. Yes.
Item 25. May I please your lordship? In last occasion, your lordship, I pray before your lordship challenging the order of sub-collector. And
We have not even received
and except for your lordship, wherein I have not given opportunity and the order which is passed by the sub-collector, ADM, it is also not.
No, but this court has to be satisfied prima facie that you have not been granted opportunity.
The opportunity. Thereafter, your lordship, I was also selected by this selection committee and got appointment and served for 1 year. After lapse of 1 year, I was disengaged without any giving an opportunity, your lordship.
So what
ST candidate.
you may do one thing, you can obtain an instruction or you can produce the file.
Yes, ma'am. But I will file the counter also positively, ma'am.
Right, if you can file the counter.
The counter along with the file, ma'am. I will produce that file. File maintained by the ADM, the appellate authority.
No. If you are filing the counter, the only point is that whether she was granted opportunity of hearing or not.
Just like the other case, ma'am.
Yes. If she was not granted, the matter will be set aside and remitted.
ବସୁଛନ୍ତି ସେମାନେ କଣ allegation ଆସିଲେ ତ ନିଜ ଲୋକକୁ ଯାହା CDPO କହିବ କିନ୍ତୁ କହୁଛନ୍ତି ହଜର ଆଉଟ ଅଫ କୋର୍ଟ ମୁଁ କହୁଛି ଆପଣ ତ ଜାଣିଛେ ସେ ମୁଁ ବର୍ଷ ଚାକିରି କରିକି ମୁଁ ତ ST କ୍ୟାଣ୍ଡିଡେଟ୍ ମୁଁ ତ ସିଲେକ୍ସନ ହେଲି ସବୁ କଲି ଜଣେ କେମିତି ରିକମେଣ୍ଡ କରିଦେଇକି ତାକୁ ସର୍ଭିସ ଦେଇ ଦଉଛନ୍ତି this is the pity. This is the crux of the case, your lordship.
Yes. So London State Council requests for some time to file counter. List this matter
19 September.
on 19th September.
ବହୁତ କେସ୍ ଅଛି 18 କରନ୍ତୁ ନହେଲେ 26 September.
26th September.
26th, yes, ma'am.
Item 26.
Pass out. बहुत pass हो जाएगा.
Item 27.
27 माने खाली 500 बनना
और
सर उधर जाएगा
यहाँ पर एडजन कर दो, रख दो, एडजन कर दो.
Item number 30.
My lord, in the last date, notice has been issued in favor of the opposite party, and the postal report is addressee always absent. Postal report addressee is always absent.
You, the State Council, yes. Try to get it served through the IIC.
मतलब this is better.
Transfer application.
नहीं
Item 30.
28 madam.
No, item 30.
30.
28.
Timoinant.
Item 30.
Yes, ma'am.
Let an extra copy of the transfer application be served upon Learned State Council.
Yes.
Who shall cause the same to be served upon the opposite party through the IIC of the concerned police station. Please indicating that the matter shall be taken up for hearing on
26 September.
Huh?
26
on 26th September.
Let a copy of the brief.
Give a copy.
Otherwise, we'll.
Sir, give a copy to the State Council.
My lord.
Yes. Place this matter on 26th September.
Item 31.
Last occasion when the notice was issued.
Yes. What has happened to the notice? Let us see office note. Service of notice completed. Notice on office note indicates that notice on the opposite party has been duly served. There is however no appearance. In order to grant one more opportunity, you wanted to transfer from Bhanjanagar to Puri?
Yes, ma'am.
All right. Allow.
Problem.
Item 32.
32, let's see, in fact, the matter became close. I am from the sole party. Last order was that I would apprise the status of the case. And the status says that on 27th of July, this the CP has already been disposed of by passing the decree of divorce.
Is it an expected divorce?
Yes.
Expected.
Again.
So he may seek to recall the order. So let him appear. Let him appear. Pass over.
Item 33.
Petitioner is the wife of the sole opposite party. last time notice has been issued.
Postal tracking report indicates that the notice has been duly delivered on the opposite party. There is, however, no appearance, despite repeated calls. Makiri won't, sir. Allow. Allowed.
Item 34.
34 also, notice has been served.
Notice has been served. London State Council submits, has informed that notice on the opposite party has been duly served through the IIC of the jurisdictional police station. There is, however, no appearance, despite repeated calls. Allow.
Item 35.
35 रे correction be made accordingly, appropriately. फिर तुम्हें इस वाले बस जाओ कि अपना भी ना पास हो रही है इसमें कितना मतलब है
36 or
37
Yes. That's it.
Yes, item 36.
Item 36.
Main case. There is a correction in the order, my lord.
कौन सी?
In the principal accused, in the main case, my lord, this petitioner were granted bail, my lord. Thereafter, taking into that consideration, my lord, your lordship granted interim bail in the true application, my lord. In 9510, my lord, your lordship granted bail, that is correct. But in 8127, my lord, that order has been wrongly typed out as 9530 order, my lord.
सर बुझिएला नहीं
8127 bail application. से order टा ठीक अछि किंतु 9510 रो टाइप हे जासी
9510 माने जस्टिस महापात्र को ऑर्डर
both are similar type.
अच्छा जस्टिस महापात्र को ऑर्डर
No, your lordship's order. Initially, your lordship has granted 4 month bail to the petitioner.
एक केस रे petitioner
No, connected matter.
सर से कंफ्यूजन करछन्ते हो E petitioner in another application was granted interim bail.
Yes, my lord.
This matter when placed before Justice Mahapatra, he said that since petitioner has been granted bail in a connected case, let it be placed before that bench. So it has come to me.
Yes.
Now what is wrong in this case?
My lord, wrong is that, my lord, in 8127, my lord, that wrong order has been typed out, my lord.
Order कितने? Order date कितने?
Order date is both are same, my lord.
कितने sir?
16/7, 16/7/2020.
16/7 order देखिए चलो नहीं इधर फाइल नहीं फाइल अच्छी
He is saying bail number has been wrongly typed.
देखे
Only saying yes.
the scanned copy is not available of that order because the last order is of Justice Mahapatra 2/7/2024. Thereafter there is no order. Let me find out from the physical record. अच्छा तो स्कैन करना था नहीं एटा आर केस है 8127 8127 of 2023. Yesterday I have granted him bail. That is in 9510. I have granted you bail on 16/7/2022.
But in 8127, in that case, my lord, 9510 case has been typed out.
अच्छी
8127.
8127 of 2023, the matter which I am now taking up. In that case, there is no order dated 16/7/2022.
But in the
Please check from the court record and then we will take up. Dita dekhi diyo to. There is some confusion somewhere.
Yes, but
Yes.
Item 37.
Please check the Mr. Mishra. Please check both the case records. Then you can approve. Yes, item 37. Pass over.
Item 38.
and pass on.
Pass over.
Item 39.
Yes, custody since 26/10/2022.
26/10?
26/10/2022.
Yes.
There are 4 accusations.
Out of 4 accused persons, 3 have already been granted bail by this court.
Yes.
Lordship, kindly have a glance to the last annexure. I have given that annexure.
Yes, I have verified, my lord, that Soumya Ranjan Behera
Yes.
is in similar footing with this present petitioner, Janmajay.
Soumya Behra.
Yes.
Where is that order?
Soumya
That
Ranjan,
annexure
page 40.
file, my lord. Annexure 4, page 40. My lord has granted bail.
Yes, my lord. The lordship has perused the statement of Jitu alias Jitendra Patra. That Jitu Patra, he has not seen the occurrence, but he has seen those 2 petitioners, this petitioner Soumya Ranjan Behera and Janmajay. They were running with the knife only. He has not seen the occurrence.
Para 7, Lordship. Para 7.
And is para 7, your lordship is specifically. And other witnesses, they didn't identify, though they were there, but didn't identify those injured witnesses.
Yes. So this is, he stands on the same footing as Soumya Ranjan Behra.
Yes, my lord.
All right.
Soumya Ranjan Behera.
The petitioner is in custody since
26/10/2022.
26/10/2022 in connection with such and such case. You are also granted interim bail.
Interim bail I was granted.
Stop. Para. Next, he was granted interim bail.
On 29/1/2024. On 30/1/2024.
Interim bail by this court as per order passed in. As per order passed in BLAPL number.
But this
In this case. ছাড়তা है দরকার নেই ব্যাপার চল এখন para 5 টাও কোট করে দে হ্যাঁ para 6 রে লেখো Mr. BP Pradhan, learned counsel for the petitioner, has argued that the petitioner stands on the same footing as co-accused Soumya Ranjan Behra, who has already been released on bail as per order passed by this court in BLAPL number 10044 of 2022. Stop. The court below has rejected the bail application, referring to the statement of one Jitu alias Jitendra Patra, recorded under section 161 of CRPC. No, he has not been indicated. That in earlier order it was there. So cut do. Ye line ta cut de. Hala. The prosecution appears to be relying upon the statement of one Jitu alias Jitendra Patra, recorded under section 161 of CRPC. है ना? तो para 7 टाको कोट कर दियो, 8 टाको 9 टाको कोट कर. Yes.
Item 40.
And corporation show एक 2020 open under section 20 we close to process.
Custody since?
6/1/2020.
Yes.
90 kilo on the petitioner belongs resident of Chhattisgarh. Trial already started. Already 3 witnesses examined out of 9. Trial is going on.
List this matter 1 week after.
Prefer target.
Target. अच्छी तरह में. All right. Learned counsel for the petitioner. Will you withdraw it?
Yes.
Learned counsel for the petitioner seeks permission to withdraw the bail application. Further seeking a direction to the trial court to expedite the trial. It is since it is submitted that trial has already commenced, permission to withdraw the bail application is granted with the direction to the trial court to conclude the trial as early as possible, preferably within 4 months. Yes.
Item 41. Option similar, 302 and 34. Opinion panel 28 on answered, madam. There is no eyewitness occurrence, madam. This present petitioner has been ordered an action in this case only.
Case diary.
case diary is there. I think the co-accused has been granted bail by Honorable Justice G. Satpathy. Once he has withdrawn after examination of Sarveswar Sahu, one Subhas Naik, and thereafter he has been released on bail by Honorable Justice Gauri Satpathy. Yes. So I think there the matter should go.
No, this must have been issued.
First time he has filed this.
No, the first matter. Hmm.
Petitioner भी first time बोले file करते.
The FIR first FIR টা বোধহয়
On Subhas Naik in bailable 1448522 disposed of on 31/1/24 by Honorable Justice G. Satpathy. Thereafter again he
it
has
appears
filed
that it appears
that
that
has
the
been
first
allowed.
it appears that the first bail application arising out of this FIR was dealt with
allow ହେଇଛି
by Honorable Sri Justice Gauri Shankar
bailable
Satpathy.
3000/20.
In such view of the matter, registry to do the needful after obtaining necessary permission of Honorable the Chief Justice.
Item 42.
My lord. It was the offense is 363, 76(2), 376(3) and POCSO Act. As far as this court is concerned, in this case is concerned, charge sheet has been submitted and trial has been started.
Notice to go to the victim, and in the meantime, PW1 informant and PW2 victim already examined. So and
6 witnesses have been examined.
yes, victim and informant already.
Where is the victim's deposition? But let
Notice to go.
Let first notice.
Notice to go.
Let notice go. Let a extra copy of the you are appearing for?
No.
Let a extra copy of the bail application be served upon London State Council, who shall cause the same to be served upon the informant/victim, indicating that the matter shall be taken up for hearing on 26th September.
26th
September. Up to date case diary along with statement of the victim. Statement in the meantime,
the informant and victim may be produced.
Deposition of the informant and victim be produced by the petitioner. By learned counsel for the petitioner.
Item 43.
My lord, on 27th August 2024, IA has already been filed, but the number has not been given by the registry.
There was a search was made in the office, but there is no IA.
No, IA was already filed on 27th August.
You must be having a receipt then. Filing receipt, you must. How? IA filing receipt
I have filed the IA from Raurkela VC, sir. I have filed the IA from Raurkela VC.
Raurkela VC, all right. You filed it in the which online e-file correction.
E-filing.
All right. I'm calling it after tomorrow. Let us e-filing let us find out. Let it counsel for the petitioner submits that she has filed the ticket again. I'm dictating the order. Kindly wait. That she has e-filed the IA on which date?
27th August 2024.
On 27th of this month. Office to find out the IA and tag the same to the case record. Let this matter day after tomorrow.
Item 44. For my regulars.
Yes.
Here, my lord, petitioner has been languishing in the
item 44. In the morning, I have received the case diary, my lord. So let it come anyhow.
Day after tomorrow?
Yes.
This is matter.
And his application has been rejected by your lordship, and so also in the FX court, my lord, Supreme Court also. Yes, I have thought. It is correct.
Your lordship has granted 3 months interim bail.
Yes.
Thereafter, he went to Supreme Court. Hon'Ble first and granted, and thereafter he has surrendered.
Which order was, I mean,
Your
which
Lordship,
or-
I have
Sir, which order was challenged before the Supreme Court? Which order?
My lord, 7363 of 23.
Which order of this court was challenged before the Supreme Court?
TLPL 70. I have annexed that order. Page 44.
Page 44. Oh. Page 44 put us down.
Your Lordship has granted 3 months for delay in trial. And also there.
No, which order was challenged? Page 44.
Page 44, 10/10/2023.
Just a moment, just.
7376 of 2023.
This order was challenged.
Yes, my lord. For extension, my lord, that was challenged. And this honorable court, honorable Supreme Court has a first instance also issued notice and also extended, my lord, also the order.
Thereafter, they rejected it.
And thereafter, see, extension tak magdil, see, surrender.
No, thereafter the bail application has been rejected by the Supreme Court.
See,
We do not find any ground to interfere with the impute order passed by the High Court. The special leave petition is accordingly dismissed.
My lord, for that extension of.
I do not know. I do not.
See, order we challenge kortila 7376. He se to se surrender kal.
So, आपको interim bail भी कहीं दिया जी वो मुझे बहुत. ये तो interim bail मांगी ना तो Supreme Court जी में जाएगा हमको interim bail दिया है.
नहीं delay जो से जाए थला.
किच्छ. No.
And thereafter.
किच्छ I am not inclined.
नहीं your lordship that.
I am not inclined Barcoli. On merit I am not inclined. As simple as that.
ସେଇଟା ଯୋଉ ହେଲା ସେଠି ହଜୁର କହିଥିଲେ ଯୋଉ examination of witnesses after examination of eyewitnesses.
Where was that order? When was that order passed?
Yes, my lordship, in the same page 44, 7376. Here, paragraph 4. Say them deposition copy uda de dite jo. Mane he
That's what this court finds that the petitioner does not stand on the same footing as the court.
Now, in the meantime, eyewitness 5 eyewitnesses has been examined, and also 164 statement. I have annexed given that 161 deposition copy of the eyewitnesses, and on last occasion I have solved, and also 5.
Yes.
I have also solved that.
Maybe. So, yes.
Let me go through. If I find anything more, today morning I have received.
Please this matter next week.
Yes. Item 45. I have also filed all the depositions before the court and also next week.
Yes, next week. 45.
Lordship, is a case of 21C, 29 of NDPS Act, Lordship. As per allegation, 2 person transporting contraband article of brown sugar, Lordship, by motorcycle. Lordship, we granted bail one of the co-accused person. There is a driver of the motorcycle, Lordship.
From him, the contraband has not been seized. It has been seized from the present petitioner. 3 kg.
Already rejected earlier also.
Yes.
Already rejected earlier.
This is the third application of the.
That will also meet with the same fate.
Lordship.
That will also meet with the same fate.
But Lordship, he is custody since 2020. Lordship.
Brown sugar पर?
Yes, Lordship.
3 kg.
Brown
3
sugar.
kg.
3 kg.
265. 3 kg.
Yes,
265.
Lordship,
I will not even pass a regional order. I will simply say I had dismissed. Brown sugar happened.
Lordship, but one of the co-accused person granted bail, Lordship.
You do not stand on the same footing.
Yes, Lordship, but as per rejection order, out of 21 witness, only rejection order mentioned that 3 witness has been examined, Lordship. But I am taking instruction, 5 witness has been examined.
No.
Lordship, as per his custody, kindly consider.
No. I have considered to reject it. In my considered opinion, this will be rejected. However, the petitioner, this is the second journey of the petitioner to this court. Okay? This is the third journey of the petitioner seeking bail. His earlier applications were rejected on merits. The present application has been filed only on the ground of delay in conclusion of the trial. This is a case where more than 3 kgs of contraband brown sugar were seized from the exclusive and conscious possession of the petitioner. Having regard to the above, having regard to the quantity of contraband seized, I am not inclined to allow the prayer for bail, which is therefore rejected. Yes.
Item 46.
46.
May I please Lordship? Present petitioner minority behind bar my lord since 1/2/2022 being charge sheeted on section 498A, 304B, 306 and 34 IPC along with offense section 4D Act manner. And present petition was also released on interim bail on time and again, and during enjoyment of that interim liberty, the conduct was very orderly and excellent, my lord. He never misused the liberty granted to any manner, my lord. And charge sheet statement shows, my lord, there are altogether 34 witnesses have been shown as the charge sheeted witnesses, and 38, my lord, out of which 25 witnesses have been examined. And
Mr. Das, relief, the maximum relief that you could have got from this case, you have already got. By order dated 1/12/2023, despite all odds stacked against you, I have granted you interim bail for 3 months.
Husband, my lord, cause of death is suicidal, my lord.
No.
Cause of suicide and he committed suicide, and independent.
No, sir, Mr. Das,
Independent witnesses have not supported the case in manner. There is no evidence to show that.
relief
There is no positive evidence. I'm serving copy. There is no positive evidence
Sir,
to show that.
Copy of the depositions.
Yes, one.
Sir. Serve on the State Council. We'll take it up next week.
Yes, one.
Learned counsel for the petitioner undertakes to serve copies of the depositions on the State Council by tomorrow.
Yes.
Place this matter next week.
Item 47.
Very difficult case.
Husband, my lord, normally.
Husband will be the difficult.
Husband suicidal, normal, this court grants bail, my lord. Normally, my lord.
But I have not granted bail means.
Not a bail is my lord's discretions. I have nothing.
No, not discretion.
Normally, your lordship may take the member. Normally, this court.
But in this case, in this case, I have rejected twice.
No, because
This is the fourth round, a fifth round.
No, fifth round. This is circumstance of your lordship. I'm
And
satisfied.
304B is there. Item 47. My lord, in item 47, the father of the petitioner has, after his retirement, had purchased a plot in the year 2017.
Your name is there in the FIR?
No, my lord. His name is not there. One anticipatory bill which has come 12032.
There was another, Hariar Muduli.
Renew prayer if any implication is there.
My only contention is that at the time of filing of charge sheet, they have stated, I have been implicated in this at the time of charge sheet. So I have come forward.
Charge sheet
has been filed.
Charge
and
sheet
in the
filed
charge
but
sheet,
All right. The petitioner's name does not find place in the FIR, but it is submitted that charge sheet has been submitted against him. Then State Council shall take instructions in this regard by producing the charge sheet for perusal of this court. Place this matter 2 weeks per crop. 26 September, till such time no course of action shall be taken against the petitioner. Yes.
item 48.
Connected record by Lord, Lordship directed, I file a miscase that.
Oh, that.
Yes, yes.
So in that connected matter, we will connected matter.
Parity shall be maintained and time may be extended. In connected record.
True.
That is 7786 of 23.
My lord, 7786. My lord, pass over, my lord.
Yes.
7786.
7786. It is not your matter.
My lord, as per
More
instruction of the conducting council.
earlier they have approved. I have subsequently filed, your lordship directed, file a miscase for extension and modifier.
It's a disposal of matter. I think he can.
Yes.
So it's a disposal of matter. He can file a IA.
My lord, the conducting council instructed to take a pass over, my lord.
No. He since the so-called conducting council is no longer the conducting council because the case is already disposed of. Anybody can appeal. Well, where is your IA 1554?
Yes,
What do you want? Parity.
Parity and time may be extended for surrender.
সেটা তো বলা ওটা IA IA মানে সেটা connected matter 1554 হ্যাঁ In order dated, no?
7/11/20.
In order dated 7/11/2023, the following may be added, following sentence may be added after after paragraph 5. Further, the courts below shall maintain the principle of parity. Stop. 2 weeks further time is allowed to the petitioner to surrender in terms of the order. The arata will not press.
Not press.
ABLPL number 1686 of 2024 not press.
No.
गोटे बढ़िया किरी हेगला कामटा आ आरटा रे गोटे भर्ती करी गोटे इलीगल ऑर्डर मोटो करे नेबे बुले वाले नहीं जाउथि मु जानि परनथि आज्ञा कोन करया कहले नाही कोन बुझनो बेला हम कोन को मते डर लागै छै कि कोन करी नहीं जाउथि
Item 49.
Allegation under section 341, 294, 323.
506, similar order to be passed.
This is an anticipatory bill.
Anticipatory bill. Co-accused has been granted on similar.
Vicky Naik.
Yes.
All right, same order.
Item 50.
Pass over. तो जा इरे correction टा कर दे. Correction be made accordingly, है ना? तो order data भूल जाइए. Yes, pass over matters.
Sir, item number 12.
Pass over.
Yeah.
Pass over कितना item?
12, 1, 2, madam. 12. Here, madam, the present petitioner was continuing as the Anganwadi worker for a continuous period, about 10 years. Because of her, my lord, maternity, she has approached the authorities and with due permission, she left. But unfortunately, madam, because of the miscarriage, she joined after about nine months. From her.
Given by the lady supervisor, Damayanti Jana, referred to by the sub-collector, now put in his
Accepted
order.
as the order.
Yes.
The original records dealing with her case is there, I have obtained. Your lordship wanted to see the record.
I think I have seen it.
Yes.
This order was that some lady supervisor, Damayanti Jana, had that statement was referred to by the sub-collector.
Yes.
But that statement itself is not available on record.
I find two letters from the villagers. One in her support, the other is against her.
We will ignore both. Unless it's an official communication, why should we accept? See, Damayanti Jana, where is that? There is no statement. But the sub-collector depends upon entirely on that statement. How?
Let the collector consider. Your lordship may direct.
Collector how to go?
No. So she was already engaged, isn't it?
Yes. I have engaged, I have continued for about 10 years, about 10 years I have continued, madam.
Had she had given any application, it is not disputed that she was suffering or she had.
Let us come to paragraph page 22 of the impugned order. Adjudicating the submission of CDP of Khariar and the appellant Gayatri. You are Gayatri Meher. Relate documents, orders of it is decided with the following. It's the fact that appellant has availed unauthorized leave.
May please.
See you operative portion.
So before taking flat line, madam.
No. The 1, 2, 3 जो लिखा है इसी रखो. Page 22.
22.
Adjudicating the submission जो लिखा है. Impugned order.
Yes, impugned order, madam.
Impugned order.
Of your brief.
More brief.
So I think it is page 27.
27.
Not pleasant.
Yes. Looks like 23. Yes.
Adjudicating the submission of CDP.
When Mr. Chand is there, naturally the court will make mistakes.
No, I was page 20. Adjudicating the submission of CDP of Khariar and appellant Gayatri Meher. Relied documents, orders of Sub-Collector Nuapada, it is decided with the following observation. 1. It is a fact that appellant has availed unauthorized leave. It is a regular process of ICDS offices that amount to transfer of regularly to the account Anganwadi center in each and every month for purchase of foodstuff. The person who was working in the absence of the appellant, she was purchasing the foodstuff. Hence, this document cannot substantiate the presence of the appellant, Srimati Gayatri Meher. The appellant was remained absent from the month of September 2018 to till disengagement. The appellant further submitted waiver dated 28/10/2018 and 8/11/2018 respectively to prove her presence in Anganwadi center, but it disclosed that she has submitted first document of WB on 8/11/2018. The receipt thereof is in evidence. It proves that the order to substantiate her presence in the Anganwadi center, she has managed to obtain these hot document. Submission of medical documents from a private clinic is not acceptable as per the government provision. If the medical certificate is genuine one, she would have authenticated the said certificate by countersigning the same from CDMO Nuapada. This has not been done, and sufficient opportunity has not been.
There are three things. There are three grounds. First is that she has unauthorized leave. Along with it, she has forged some documents according to the allegation. What is the finding? Who to finding the hala for the forgery of documents?
Because of the fact that I have submitted certain, because let me see, for to operate the Anganwadi center, each and every month I have to procure the foodstuff from the concerned authorities, and suppose I have purchased egg, I have to submit the bill, and accordingly I have submitted the bill. So it is their submission that I was absent, but it was managed by me by somebody. But no, to that, neither the particular so-called report by embassy, that is not there.
शोकज रहला जे बिना अनुमति दीर्घ कार्यकरी केंद्र बड़ा प्रदर्शन करते शिशु पत्र संख्या एते तो आपन को कैफियत मगा जाइथिला वेयर इज दैट ओरिजिनल शोकज नोटिस
ओरिजिनल शोकज
अधिकारी पत्र संख्या 593 डेटेड 22/10/2018
माल
105 डेटेड 2/2/2019
सेगुडा
चारिटा
से all those things are not there, and one thing मालूम है
और नॉट देयर माने
तो ये एलिगेशन नथिला जे
मेरे से डॉक्यूमेंट उडा काई
जो फूडस्टॉप डॉक्यूमेंट सेवा किछ देना थे
नहीं आपन से कहला पर दीर्घ दिन अनुपस्थित रही केंद्र परिचालन अवहेला प्रदर्शन कर शिशु विकास प्रकल्प अधिकारी खड़ियाल पत्र संख्या सो डेट यू चार्टर लेटर आपन को कैफियत मगा जाइथिला
nothing has been given to me, that's why the disengagement of order.
So where is your reply you did not give any reply.
No, I have been called for, because no, nothing has been solved to me, and my
सर ये जो कारण दर्शाव नोटिस था आपन एनेक्सर करछिन ना
नहीं ये जो कारण दर्शाव नोटिस है गया मालूम बेसी
तार रिप्लाई कोन देले
आगे Annexure 5 में
एनेक्सर एडवर्टाइजमेंट
आगे मत they have not submitted me any so called
आपन कोड आने देले शो कोड नोटिस था
मत आप कोड देले गया मैं काली का प्रीसेट
चाकी साला पर आपन शो कोड नोटिस
गया देला I have approached the code, the server code directed let the concerned petition be given opportunity of hearing, and that's why annexure 4 was ballot for
subsequently
नहीं किंतु ता पूर्व ना after this I was the fact like this matter the petition was allegedly remain absent from the month of January. It is my case. They are saying that from September 2018, it is my case. From January 1st of January, I went for medical check-up. In the month of July, I returned. I approached the authorities, but they have not served any notice. Nothing has been given to me. Rather, I came to know that I have been terminated. I approached the Honorable Court, a person director of the Honorable Court. They have given me an opportunity of hearing a person appearing with person before the sub-collector, and this is order at 19, page 19, answer 4 is the order of the sub-collector. Thereafter, these things has come up. And
you produced the file, Mr. Dabras. You produced the entire file.
Original file I have received.
And one more thing, I want to point it out.
No, you see, you have enclosed this show cause notice as Annexure 3.
Madam.
Now you claim that you have never received that notice.
Yes, that is my.
So how did you get this notice then?
No, subsequently, when I appeared before the sub-collector, at the relevant time, before that I was terminated. And one more thing I want to point out.
No, again, you are not answering my question. How did you get this notice then?
No, I'll appreciate. They have thrown me out. I approached the Honorable Court.
Yes.
And the Honorable Court has directed, because of the fact there nothing has been, no cause, nothing. You are hereby directed to appear with the sub-collector and file your response. I appeared. I was personally hurt. And during that particular process, they have given me.
Who have answer करना? Annexure 3 टा अपन फाइल किंतु.
Annexure 3 पर से sub-collector appear कला पर है क्या?
कला पर अपन देबे कोन पे?
Already they have reflected this. They have also reflected in the particular order matter. And one again, and one more thing I also pointed out, it is their paper publication. The paper publication was made on 10/7/2019, wherein they said that by 6/8/2019.
No, Mr. Chand, the facts are not clear. Facts are not clear at all. Yes, you have the entire file.
Yes, this is what has been sent to us.
पूरा फाइल देले पर्सनल फाइल
ତାଙ୍କ ହିସାବରେ 24/7 ଶୋ କରିଦେଲେ 9/8 ମୁଁ ଚାକିରି ପଳେଇଲା।
କେବେ କେବେ ଆପଣ ଶୋ କରି ଦିଆଗଲା
ସେଟା ଦେଖ ମ୍ୟାଡାମ ମିଶି 24/7 ପୁରା
24/7
ଟପ୍ ରେ ଆଜ୍ଞା ମ୍ୟାଡାମ ମିଶି annexure 3 ଟା page 18 letter number 1749 dated 24/7/2019 ମ୍ୟାଡାମ କରିଥିଲି ମ୍ୟାଡାମ page 18 ଆଜ୍ଞା
ସେଟା ତ ଆପଣ ରିସିଭ କରିଛନ୍ତି
ଆଜ୍ଞା ଏବଂ ସେଟା ସେମାନେ କହିଛନ୍ତି 9/8/2019 ରେ ଟର୍ମିନେସନ ଅର୍ଡର ଆସିଯାଇଛି।
ନା ତା ପୂର୍ବରୁ ଗୋଟେ ନୋଟିସ ବି ଆପଣ ରିସିଭ କରିଛନ୍ତି ୟୁ ହାଭ୍ ରିସିଭଡ ଏ ନୋଟିସ ଇଜ ଇଟ୍ ହିୟର अवेलेबल ରିସିଭଡ
ମୁଁ ତ ଜଏନ୍ I have joined in the month of July
July 2000
July 2019 ରେ
you have received it on 23/3/2019
23 it's relevant to I was medically valid as under
please go through these documents and prepare a date chart to assist the court
and
No,
one
they-
more
the facts appear to be a little bit I mean complicated
ଆଉ ଗୋଟେ
confusing
ଜିନିଷ let me see the paper publication
Hmm.
in the paper publication they have given me the time that appear by 6/8/2019 it's
Time,
admitted
paper publication
Aiyah,
time.
their counter by see their counter page 21 their own counter page 21
Annexure କେତେ
annexure se করছে 21 is page annexure C/3
C/3 is some grievance petition
again paper publication there it is their counter
that is not the paper
page page I'm sorry page 21 নির্দিষ্ট I got it ଆଜ୍ଞା ସେ ଏଇ ଯୋଉ ପେପର ପବ୍ଲିକେସନ ମାନେ ବେଶୀ ଗାୟତ୍ରୀ ନଗର ସଚେତନ ଯଥାକ୍ରମେ ଗତ 2018 ଗତ 2016 ରୁ ଏଥିରେ 16 ଆସିଲାଣି ତୁମେ କେନ୍ଦ୍ର ବିନା ଅନୁପସ୍ଥିତ ରହିଛ 19 କଥା 16 ଯାବି ହଉ ବାରମ୍ବାର ତୁମକୁ ପତ୍ର ମାଧ୍ୟମରେ ଜଣାଇଲେ ମଧ୍ୟ ସୁଦ୍ଧା କୌଣସି ଉତ୍ତର ଦେଉନାହ ନିଜ କର୍ମକ୍ଷେତ୍ରରେ ଅନୁପସ୍ଥିତ ଅଛ ଏହି ଖବରଟିକୁ ଖବରକାଗଜ ମାଧ୍ୟମରେ ତୁମକୁ ସୂଚିତ କରାଯାଉଛି ଯେ ଆସନ୍ତା 7 ଦିନ that is 6/8/2019 ତାରିଖ ମଧ୍ୟରେ ନିଜ ନିଜ କର୍ମକ୍ଷେତ୍ର ଯୋଗାଯୋଗ କରିବ ନଚେତ ଆଇନ ଅନୁଯାୟୀ ବିରୁଦ୍ଧ ହବ ଦଣ୍ଡ ଦିଆଯିବ ସୋ ଏଇଟା ହେଲା ଆଜ୍ଞା ଦିଆଗଲା ଲେଟରଟା this was on 29/7/2019 ଏବଂ ସେ କହିଲେ ଯେ 6/8 ଭିତରେ ତମେ ଜଏନ କରିବ they have terminated me on 9/8/2019 so where is show coach kasi show coach se କହିଲା ଯେ 23 ତାରିଖ show coach ହଉଛି 24/7 ର
you have given a bunch of show cause notices under annexure A/3 series just refer to the file and see whether these notices were actually served or not correct
ଆଉ ଗୋଟେ ଖାଲି ମାନେ see page 23 of the same matter is holding 21 next two page this letter annexure C/3 I got it man page 23 of their counter ସେଥିରେ ଏଇ letter I was terminated from 9/8/2019 they have annexed the letter that ତୁମର complaint ଅଛି 14/8/2019 ମୁଁ 9/8 ମୁଁ ଚାକିରି ପଳେଇଲାଣି 14/8 ତା 5 ଦିନ ପରେ ଲେଟର ଲଉଛନ୍ତି ମୋ ନାଁରେ କମ୍ପ୍ଲେନ୍ ଅଛି ବୋଲି ମାନେ ସି ଲେଫ୍ଟ ସାଇଡ जो 10 कटा আছে তা তলে আছে 14/8/2019 ডেট অফ অর্ডার page 23 annexure C/3 by then I was terminated or decision is matter now they have inserted this letter to establish that I was not duty or not doing all such things and the letter of the villagers complaint of the villagers this paper publication joined by 8/6/8 2 days after I was thrown out
Look on the heard and part. The original personal file of the petitioner as maintained in the office of the CDPO is available with the State Council. Learned counsel of the petitioner forcefully argues that no notice or show cause was served upon her before issuing the order of disengagement. The state has, however, taken the specific stand that due notice was the proper notice was served upon the petitioner at all times. So since the original file is on record, the State Council is requested to verify the same and to make his and to assist the court accordingly. Please this matter next week. Complete.
Since we date.
It is a file to देखिए करो है ना ये देखने बोल रहा हूँ 20 yes. Yes.
Lordship, item 20, Lordship. I'm initially appointed for the post of your Lordship. Probably my lords was hearing this matter earlier. Meanwhile, due to change of assignment, you went to some other bench, then now it has come back.
Yes.
The challenge here is Annexure 9 series.
Annexure
9 series. That is at page 51 onwards. Look, this is regarding appointment of Jogan Sahib. Yes. Appointment of Jogan Sahib. The not sell. Quickly, what is the problem here? Petitioner and the private opposite party, they were the applicants. And others were also applicants. The petitioner was selected. And I'll tell you, Lordship, there was though some mistake in my selection, but he was selected. Appointment order was issued. Unsuccessful candidate approached this honorable court. Got an order to consider his representation. Now his representation was considered. Collector called the selection committee. Selection committee reviewed that selection, terminated me. So that review and termination is under challenge. Annexure 9 series, what I am trying to show your Lordship is the termination. If a Lordship sees, page 52 is the proceeding in the meeting. Then 53 is that basis of termination. That's slab of marks secured by the respective candidates. That will be the point for consideration. Lord, before I take your Lordship to the validity of the order, I'll straightway take my lords to the page 42. The basis on which I was selected. Kindly see, page 42.
Yes.
Lordship, may kindly see, my name is Sangita Muni.
Yes.
The other side is Gitanjali Raut.
Gitanjali
Raut. Lord, what is the process for selection? 30% from matric, 30% from plus 2, and 40% from plus 3. Lord, that your Lordship will find from page 42 itself.
Yes.
30, 30, 40. Now, Lordship may see, as against my name, Sangita Muni, my 10th mark, your Lordship may kindly see, it is 395. This is the first selection by which I was selected. 395. This is inclusive of the extra optional. This is inclusive of the extra optional mark. Deducting extra optional, it will become 374. Am I clear, my lord? They committed this mistake even at the time they selected me. Lord, this I am saying before my lordship, consciously saying. 395 is the 10th mark. Then plus 2 mark, there is no dispute about this 388. Now plus 3, they took a wrong mark, which I have never secured. 1142. I never secured 1142. My mark in plus 3 is 1059. But they took this wrong mark and selected me. My total percentage was calculated to be 57.60 and his was 57.20. Now, after this High Court intervention and recalculation, Lordship will kindly see that recalculated mark.
Page?
But that is at page 8. Page 53.
53.
Right. This is the short point for consideration. There is nothing beyond this.
Yes.
Kindly see page 53. Now I am at serial number 2. Let's get it, man.
Yes.
Now this again 395 from 700
Serial number 2.
at serial number 2. Let's get that 395 from 700, whereas this should be 374 from 600.
650.
650, and my percentage will come in that process 57.54. Lord, I'll show the law if extra optional is to be calculated or not. I'll show the law. But 395 with extra optional, then plus 2 there is no dispute. Plus 3, they have now taken the correct mark 1059. Accordingly, they have reduced my percentage to 57.07. The contesting person is 57.19. Now the point is whether reducing my percentage, taking extra optional into consideration is correct or not. This is the only point for consideration. Now I'll request my lords to see my matrix certificate from Gujarat Board. 80, page 21. Page 20.
Yes.
Let's you got page 20. Let's see 395 from 700 at this grand total mark obtained out of 395. The total mark is 700 mark. Let's see the subjects 300, 400, 500, 600, 50, 50, 700. Now they themselves have clarified just below that without extra optional 374 out of 650, my percentage comes to 57.5. If this is the law that in your selection process, extra optional can be taken into consideration for the purpose of awarding a division. But in the selection process, extra optional cannot be taken into consideration. That's the settled position of it. Now, if they take this 374 out of 650 into calculation, then my percentage will go higher than this contesting person. Kindly see note 57.54, whereas they have taken page 53, 56.42. This is the only short point mirror. Beyond that, there is nothing to be adjudicated. Now you will also see the judgment.
Have you given the judgment?
Okay?
Have you given the judgment?
I am just giving you. Para 8 and 11. Right. 2015 SEC online 117. 2015.
I think it's yours a copy.
এটা যদি কহিবে মু আজি দেই দেবো যা করি
Let him complete. If necessary.
I'll see.
If necessary, we can take it up tomorrow also, if necessary.
Sir, tomorrow ଟିକେ মতে এক্সকিউজ করে
Hello, ଦେଖିବା ମୁଁ tomorrow ବୋଲି ଆଉ ଅଫହାଣ୍ଡ କହିଲେ
ମୁଁ ଆପଣଙ୍କୁ କହିଥିଲି ଆର କେସ୍ ବି କହିଥିଲି
ହଁ ହଁ ଠିକ କୁହନ୍ତୁ ଏଇଟା କଣ ବଟା
sir 8 and 11.
8, yes.
It appears from the advertisement that total post advertised for the scheduled caste category was 66, including post reserved for women. It was decided in the first recruitment committee meeting held on 23/7/11 to validate hard copy of the application to the tune of 5 times of the post of each category. Accordingly, in the category of scheduled caste, those who have secured 66% weightage mark from the top were only considered for validation. Thus, 305 applicants were initially decided for validation to fill up 55 posts under scheduled caste category for which advertisement was made. Subsequently, with due approval of the next recruitment committee meeting, the cutoff weightage mark was reduced to 65% for validation to accommodate more applicants in the said category. The total weightage mark of the petitioner was calculated 63.66 on the basis of online data submitted by him at the time of filing application. As the total weightage percentage of the petitioner was less than 65%, his application was not considered for validation. On the basis of data furnished by the petitioner, he has secured 574 marks out of 1100, including extra optional, of 528 out of 900 without extra optional in his plus 2 examination. All these applicants at the time of submission of their online applications were instructed to fill up the marks secured by them in different examinations. The petitioner at the time of application had submitted his total plus 2 mark, including extra optional, that is 1100 instead of 900. Therefore, his application was later validated. His +2 mark has been corrected as 528 out of 900 without extra optional, and his calculated weightage percentage for his +2 mark has been revised to 11.7% instead of 9.60 as calculated earlier. After validation, the petitioner's total weightage mark stands 65.3%. At the time of publication of provisional merit list, the petitioner had made an objection. Consequently, a subcommittee was constituted by the recruitment committee for examination and disposal of objection CGPA mark secured by the petitioner. Objection received against the provisional merit list published. The conversion of CGPA mark secured by the petitioner in his BTech was converted to percentage on the basis of the communication received from the registrar BPUT addressed to so-and-so government department, and thus the objection for recalculation of his BTech mark was not considered by the subcommittee. Now kindly turn to para 11. Yes. Para 10 and 11 kindly similar. Well, extra optional is not to get. Yes. The petitioner at the time of application has furnished the information shown similar. Kindly see para 11. There is no pleading available on record indicating which the selection candidate has been considered by awarding erroneous CGPA marks. In absence of specific pleading in the application calculation sheet in respect of other candidates, refrain from making observation awarding CGPA different
This will not be relevant. This may not be relevant.
It is there. One line is there. Extra optional is not to be taken into consideration. That is there. I have read it. Put it, highlight. Extra optional is not to be taken into consideration. It is there. I'll find it. I'll just show it. These rest are blood. I'll point out that line.
No, that is on paragraph 7, issue number 2, but that is the submission of the council.
No, it is finding is there. Extra optional is not to be taken into consideration. I have read it. I'll just point it out.
Anyway, देखिए,
but that is the point.
So it is your contention that extra optional should not have been taken into consideration.
At both the points of time. In the first selection also, they had erroneously taken my extra optional into calculation. In the second point also, they have taken extra optional into calculation. Extra optional for the purpose of.
So it should have been that 374 by 650.
650, which leads to 57.54. If this contention of mine is accepted, then I have a case.
Yes. Yes, sir.
Let my learned friend, I'll just look at the judgment, my lord. What I am seeing, my lord, may lord take my lords to his application, my lord, which has not been filed by him. We have filed it in our counter affidavit.
You are opposite party number 10.
10. My lord, and also, my lord, that extra optional, my lord, the concept of extra optional, my lord, if taken out or not taken out, correspondingly, my lord, it obviously can't be 395 because that 100 marks also will go now.
50 marks, not
50 or whatever marks, my lord, will go. So therefore, that also has to correspondingly change. So that is the first submission of mine, my lord. That supposing, my lord, the extra optional is taken out or not taken out, I don't know what has happened in my case, my lord. I'll just check that, my lord. My lord,
subject if my learned senior permits, I have checked up his mark also, subject. We can reach at a consensus. Can be taken up on some other day after examination. No problem in that.
No. I am only saying.
As he is concerned, he has 2 optional subjects in matric, but 2 optional subjects are compulsory subjects. That's not extra optional.
My lord, what they have, my lord, their application, my lord, when they made the application, they made 2 things, my lord. One, they did not give the +3 marks. They did not give the +3 certificate, my lord. It postulates that you have to give a provisional, otherwise they had given a provisional, my lord. My lord, we kindly see there's an additional affidavit where I have demonstrated what is the application that he has made, my lord.
Yes.
It's at page 2 of an additional affidavit, my lord, dated 30/8/2023.
The tabular.
Yes, my lord. 10th, 20 Gandhi, Gandhi so and so, 395 marks out of 700, 57.54. Then, my lord, 215. I'll show, my lord, even the documents, my lord. 391, 700, 700, 700, my lord. Well, that calculation has been made by the expert authority, and then they have come to the conclusion, my lord, that whether it can be faulted or not is first point that my lords have to examine, my lord. When the expert body, after having applied their mind and come to the conclusion, 1. 2, my lord, may kindly see page 8 of that very affidavit.
Yes.
Therefore, request you to please give me 1 month period to submit my +2 certificate.
So this is +3 exam certificate.
Yes, that is a mandatory condition precedent for the purposes of zone of consideration, my lord. Zone of consideration, that is the advertisement says that you must be a graduate at the given component time, my lord. My lord, as far as career is concerned, my career is far better, my lord. I have two first classes, and except matriculation, and matriculation also have more marks than that, my lord. If you take out, my lord, that concept, I will add that and demonstrate to my lord. That is the point which they have already decided in their that expert committee, which had 2 other people outsiders also. Then they came to the conclusion that mine was more, and then they terminated her and gave it to me. And then till date, my lord, I have not been appointed. Here's the fact that there is no interim order, because Sarpanch is with them, my lord, and I have been kept out. I mean that very post, my lord, no one is there, my lord, now. And then at one time they began paying 50%, 50%.
If we look at the matter from the angle of the petitioner, as he has, raised, one point is that whether the 4th optional marks, extra optional marks, are to be added or not.
Yes.
If they are added, what would be the consequence? And if they are not added, what would be the consequence?
Yes.
This is the only thing
that has been taken.
Now, Mr. Ratha is trying to demonstrate that 4th optional marks are required to be deducted.
Their first applicable, their writ in the writ, my lord, they.
No, but he was fairly submitted that wrongly it was added in the first occasion.
And my lord, I'll demonstrate that the certificates, my lord. How the problem, how it's occurred. My lord, kindly see page 9.
Page 9 of
that additional affidavit, my lord.
Yes.
My lord, major mark. She's a master of commerce. My lord, kindly see the marks.
Yes. 53, 53, 57, 56, and 63.
The balance, my lord, 1, 2, 3, 4, 53, 54. After that, my lord, I cannot, nothing is confirmed how much of marks she has got. Additional affidavit, please. And their response, they have filed a response also, my lord, to that. Reply, sir.
They've given a copy under annexure.
Yes.
Let my senior complete, I'll explain.
And then the addition, then, my lord.
Graduation certificate foundation.
My marks in juxtaposition, my lord, are there in the counter affidavit. Counter qualification. They admit the qualification. This is state, state or forget about state.
No, the marks are not disputed. What is disputed is the methodology adopted, whether to include that marks.
No, mine had never been included, my lord.
No,
and still they found.
No, let us come to the final that merit list or whatever assessment, temporary comparative assessment.
Yes.
Where is that that table you were showing?
That is at page.
The reassessment, my lord, is to be looked at.
That is at page 42. The first selection is
the subsequent.
Subsequent is page 52.
Page
53. All right. Yes. Let us see that 53.
Yes,
I would have confusion.
This is the only thing.
Yes, ma'am.
You see Gitanjali Raut, 400, you are Gitanjali Raut.
Page 53.
408 out of 800.
Yes.
800,
my lord. Yes. Then that becomes, but that has to be That balancing, after that balancing, my lord, I become higher, my lord.
Now they have taken 395 out of 700.
Yes,
Yes.
Which according to Mr. Rathore should have been 374 by 600.
650.
That, my lord, I am not very sure, my lord. That I'll have to find out, my lord.
So
Because
that is the crux.
yes, that is the crux, and that is not been, that was never an argument earlier, my lord.
That was all throughout being argued.
Anyway, it's a point of law.
Yes.
According to Mr. Rathore, the fourth optional should not have been
Included
should be
above.
deducted or yes.
Well, her application was with fourth optional. And her application, my lord. I am not saying about.
So we should take it up next week. You please examine both of you.
Yes, and my lord, may kindly also take the state government's.
I will. What will be
Yes.
the response of the state government?
Yes.
I would like to also know about it.
With respect
All
to
right.
the extra optional mark, my lord.
Is there any policy? There must be some policy.
I'll check it because, my lord, that is not a ground, my lord, of the.
That
selling
ground has
the
not been
particular-
taken, my lord.
Are selling the impugned order, my lord. That is not one of the
But
ground.
that is the ground page 5 cannot see. What can you see, Mr. Council? Mr. Patnaik has not seen it. Page 5, Rohit, page 5 of the writ petition kindly similar para 4. This is the only ground.
Anyway,
This is the ground taken, specific ground taken.
all right. Part and part. In course of hearing, it is stated at the bar that the crux of the dispute lies in the question whether the extra optional marks are required to be deducted for the purpose of comparative assessment of marks of all the candidates or not. This court would like to know the specific response of the state government, state council in this regard. As to if there is any specific policy for calculating the marks of the candidates. List this matter. Shall we take it up next week then?
Yes, my lord.
Next week? Next week.
Sir, August, এটা সেপ্টেম্বর দেখিও না 5 তারিখ আসু স্যার
List this matter on 5th. With হবে না কেতরা পাঠানো আছে একটা পাঠানো আছে We'll take it up on 12th. সেটা চারটা পাঠানো আছে so Mr. Das 12th
In event I am not, if I am not here, my lord, I do it virtual, my lord.
not an issue.
That's only.
Virtual is always open.
The senior is omnipresent, madam. Both in Supreme Court, High Court, double, kindly see.
No, the technology has made it possible.
And double bonanza for my learned senior Mr. Das.
That I have no comments.
My lord, we were doing a matter, he was there with me, my lord. 75% of the liquor matters are with him. So I was asking the court whether it is payment is in cash or in kind.
Yes.
Not answered that.
Again, no comments. From the bench.
That also has no comment.
No comments from the bench. But maybe outside I can. Mr. Rathore knows that. Yes.
Item 21.
Very short matters. You also straight to come to the impugned order. This is arising out of an advertisement.
Annexure?
Annexure 5 series at page 68.
68.
Yes. Page 68.
Yes.
Annex 5. That is the impugned order. And this is a order of pursuant to an order passed by this court. This court order has been also quoted. I'm straight for taking to lordship to the conclusion part at 76, running page 76.
76 is another order, which starts at Annexure 6 at page 73.
That very order, impugned order is dated 2011-2015.
So then that ends at.
Sorry, your lordship is absolutely correct. Absolutely. That is Annexure 6. I'm sorry.
So we'll go to the page 71.
Page 70, that starts from page 73.
Yes.
Annexure 6. Order dated 5/9/2018.
Yes.
First page, the order has been quoted. Consideration matter was remitted back to the authority for consideration. So state will come to the operative person. Conclusion at page 76.
Yes.
The claim of the petitioner has been relooked into and hold that the selection of Shiksha Act during 2006-7 in Bhadrak district was made strictly relying upon the judgment passed by the Honorable High Court in case of Chandramani Jana and others on merit, taking Bhadrak Revenue District as a unit, irrespective of residence, and the candidature of the petitioner was not considered on the ground of securing less mark than the cutoff mark for the respective categories of post. This is the order. Now you are straightway. So you have delivered a judgment in the meantime. Kindly give. There are two persons, Shailendra Panda and another, Bhaskar Chandra Das. Just I will take one paragraph of your lordship's judgment, then I will take your lordship the merit list, what is their position, what is our position. You also come to page 4.
4 of the judgment.
Page 4 of the judgment. One paragraph. Fifth line from the top.
Yes.
The petitioner submitted representation, but the same came to be rejected by the secretary on 2011-2015. Here also the same thing. The petitioner again approached the court WPC number so and so 2016 by order dated 21/6/2018. This court quashed the order of the secretary passed on 2011-2015 and directed that the petitioner case shall be reconsidered and accordingly remitted the matter to the secretary to take a fresh decision within 6 weeks. Since no action was taken, the petitioner filed a contempt which was disposed of, directing the opposite party to comply with the order within 3 months. The petitioner again filed a contempt on such and such that during pendency of the said contempt application, a compliance affidavit was filed by District Project Coordinator SS Bhadrak, enclosing herein copies of the order of engagement issued in favor of petitioner on 6/8/2020. In those two cases, the cases of two petitioners, Shailendra Panda and Bhaskar Chandra Das, who are the petitioner in WPC number 10125 of 2021, they issued the appointment letter. Here is a case where you also have dealt with.
No, they. I think the petitioner further agreed by issuance of
the.
Oh, as they have been engaged not as शिक्षक but
ताको करते डायरेक्ट 2020 तो अपॉइंटमेंट देले जूनियर टीचर करते से कहले अपने लॉर्डशिप डायरेक्टेड that why not they will be considered in terms of that national benefit they have not say allowed that application. I am not so much concerned so far that. But appointments were made to those persons on 6/8/2020 to whom Shailendra Panda and Bhaskar Chandra Das, who are the petitioners.
Yes.
Now you also kindly come to, and now the conclusion in the interim order is was not considered on the ground of securing less
than the cutoff marks.
Less marks. You also kindly look to the rejoinder, the merit list, final merit list have enclosed. Revised merit list.
Page
35. Internal page of course.
তাহলে annexure টা কই দিলে better হবে।
Annexure হচ্ছে
8 হইতো কি 7 না 8?
Annexure 8. Start from page.
Annexure 8. Let's start from page 19.
Yes.
Page one dekha. You also kindly come to serial number 204 at page 35 of that rejoinder. Page 35.
204.
Yes, 204. That's the name of Shailendra Panda.
Yes.
Not sure. Percentage.
But the percentage also see that what percentage they have secured. He has secured 47.45. And what is the category? UR. Just ticket. So देखले.
Okay.
Shailendra Panda. See the petition.
47.45. Yes.
Okay. And category देखो the top row, left hand, right hand side. Category UR. Percentage are देखले 47.45. Now, sir, kindly come to serial number. So far, the present petitioner concerned serial number 172, UR category.
172.
Yes, sir.
172 is Vijay Kumar Samanto.
Yes, petition number 1.
48.24.
48.24. See 47 48.17. And Vijay Kumar Samanto, so and so. Say Bhadrak Education District. And category madhya dekhontu UR. And I upper dekhontu revised list. Compliant to the order of the High Court.
Yes.
WPC number source. Similarly, other petitioner also their names find place. I have prepared a list also. Petitioner number 3 hochi that serial number 14. Auta hochi Amitabh Mishra serial number 38. Gajendra Prasad hochi serial number 40.
Now, what I would suggest is you make out a comparative list, give it to the State Council. Give a copy to the court after argument is over, but you give it first to the state council so that he'll be in a position to respond. Huh? All right. I'll take it up on some other day. In the meantime, you give a copy.
Yes.
Heard in part, place this matter on 19th September. अब कौन करिबी जे पाठाडोडा जो रही
लोड ହେଇଯିବ
पाठाडोडा
ମନେ ଅଛି ଚେଞ୍ଜ ହେଇଯିବ ମୁଁ ସେଇଆ କହୁଛି କଣ 19 ତ ମୁଁ ନାହିଁ ଟିକେ 15 ପୂର୍ବରୁ
कर दे
15 ପୂର୍ବରୁ
12 September. Place this matter on heard in part, place this matter on 12th September. In the meantime, learned learned counsel for the petitioner shall provide a comparative shall provide a tabular the list of the candidates and the marks secured by them
and
to the state council
been selected also
vis-a-vis the selected candidates. Correct? To the state council within 3 working days. To the state council, Mr. S.N. Patnaik, within 3 days.
Item 23.
23. Yes, what is this matter?
23, your lordships, it's that certificate which is under challenge on the ground that whatever the state has done doesn't have jurisdiction to do so.
Yes, what is this, Mr. Mishra?
Your lordship, on the last occasion, I had pointed out that for few opposite parties, I had not rendered appearance.
Now you are appearing for all.
Except two. Two have resigned from the body, so they did not sign. That is.
So you are appearing for 7 to 15. Or 7, 8,
all the
10, 11, 15.
except 9 and 14.
9 and 3.
9 and 14.
Achha, 9 and 14 you are not appearing.
I am not appearing.
Who is appearing for them?
No one.
Notice has been issued?
No, your lordship. Notice has not been issued.
He came on the first day and submitted, I'll appear for everybody. Otherwise, regular notices would have gone. And that is the reason
But
he was on caveat.
No, Mr. Rafa,
Submitted to the court.
That is true. But if notice has not been served as yet.
Yeah, we'll take it on those 2 people.
Yes, so that would be better. Unless we regularize the matter, why should we take it up for finally?
The whole thing happened is because of this. Because he kept submitting that I'll appear for
Now that he says that that opposite party number 2 is no longer opposite party number 2 is the collector.
2 is collector. 9 and 14.
9 and 14. Okay.
And in fact,
Tapan Kumar Das.
he filed every counter and everything.
No, but this Tapan Kumar Das, according to you, is no longer the.
So that's
no longer an body member of our body.
That submission is itself is incorrect.
Anyway, you take notice.
Yes, all that we are saying is that if these 2 people have not appeared, we'll take. That's all.
Achha, how?
Not their.
Sri Aditya Mishra files Wakalatnama for opposite party number 7, 8, 10, 11 and 15. As it appears, except opposite party numbers 9 and 14, all other opposite parties have been represented by Sri Aditya Mishra.
Private opposite party. So does government.
9 to 14, 9 तो समझते हैं 9 तो ऐसे समझते अच्छा हाँ other than has appeared for नहीं कौन लिखे all other private opposite parties have been represented by Sri Aditya Mishra. Issue notice to respondent opposite party number 9 and 14. You will take notice by speed post?
We can take the Asti services here also because we want the hearing to happen.
Then take by special messenger?
Lordships.
Issue notice on opposite party number 9 and 14 by special messenger, the cost of which shall be assessed and deposit be made by tomorrow. A short returnable date be fixed. Let's this matter next week. Let's this matter.
26 September.
26. Let's this matter on 26th September. 26th, I mean August. 26th September. Speed post special messenger. The first week reported it.
12 September.
12th September. 5th. On 5th September. I'm fixing the date to 5th, but with the, with the understanding that if it is not possible on that day, because there are quite a lot of partnered matters also on that day. So then, okay, that's all.
At least the appearances and everything at least will be completed.
Yes, once that is regularized, we can take it up for final hearing. We can fix a date and comfortably we can hear this matter. I don't know why this matter has come to me.
Your Lordship, because the earlier court, it did not want to take up because probably it had some link, some concerns with
It was before Justice Patnaik.
No,
esteemed
Lordship,
Justice
Justice esteemed.
Sanjay.
Oh, Sanjay Kumar, sir, probably he must be concerned.
Yes, so that's why he said.
All right.
Item number 26.
Item 26, none appears on repeated calls. List this matter 1 week after.
Item 27.
27.
All lordships attention, last order, 88,024. That is the order passed by the lordship seeking report from trial court. As to under first circumstance, the proceeding was continued.
Not yet received, huh?
The stay was granted.
Not yet received. Ask the court below to submit the explanation as called for, as to submit the report as called for by this court. The report should reach this court by by 4th of September. List this matter on 5th September.
Well, I have
Interim order.
obtained this
Interim order to continue.
the certified copy of entire order sheet of Lord's Web.
But
In view of that, that report may come, but the last order was on what basis the London trial court
because
proceeded.
Asian resurfacing କରିଛନ୍ତି କି ସେଟା ବା Asian resurfacing ପରେ ଇଏ ହେଇଗଲାଣି
ହଁ ସେଟା ପରେ ହେଲା କିନ୍ତୁ ସେଇ ସମୟରେ ଯେହେତୁ
ତାପରେ ସେଟା ହେଇସାରିଲା ପରେ ତାକୁ ସାଙ୍ଗେ ସାଙ୍ଗେ ଇଏ କରିଦବା କଥା
ହଁ
ସେଟା ପ୍ରୋସିଡ କରି ଯାଇଛନ୍ତି so they let this administrative aspect
I not pass any since I obtained the report.
this is necessary for the administration of justice in the state.
Yes,
that is
shall I
necessary.
file that certified copy?
Don't file it now, let him serve, but probably the intimation has not gone to the court. Hala. This order be communicated to the court below forthwith. Yes.
4 ତାରିଖରେ
Huh?
5 ତାରିଖରେ
ଆସିଛି ଏଇଖିନା ଆସିଲା କୋଉଠି
ଆସିଛି ସେଇ ବେସିସ୍
କଣ କହିବ ଏଇ ପିଲାମାନଙ୍କୁ ମୁଁ ସେ ଲେଖିଲେ ଯେ କେସ୍ ରେକର୍ଡ ଯେହେତୁ କପିଂ ସେକ୍ସନ କୁ ଯାଇଛି ମୁଁ ରିପ୍ଲାଏ ଦେଇପାରୁନି ରାଇଟିଂ ଟୁ ଦି ହାଇକୋର୍ଟ ଟେଲ୍ ମି ହ୍ୱାଟ ଆଇ ୱିଲ୍ ଡୁ
ଆମେ କପିଟା
civil judge. You take it up, take cognizance of this in the administrative side, this will amount to contempt, sheer contempt. I verified the case record and it was noticed that all the order sheet of that suit were sent to the copying section on Ete in reference to copy application number Ete filed by the plaintiff. However, I have directed the Sirastadar to bring the order sheets of the case record from the copying section by on 3 sat for preparation of the report. Let this be brought to the notice of the chief judge, the district judge. Look, a report has been received from the civil judge Puri, indicating that after on verification, it was found that the order sheets of the civil suit in question have been sent to the copying section on 28/2024. In reference to an application filed by the plaintiff for grant of certified copies. Accordingly, the civil judge has directed the Sirastadar to bring the order sheets of the case record for preparation of the report. This court is surprised by such attitude exhibited by a judicial officer in response to an order passed by this court. Stop. The civil judge is directed to transmit to submit the explanation as directed by this court within 2 days. Let a copy of this order be forwarded to the district judge Puri for obtaining the necessary report from the officer concerned and to transmit the same to this court within 3 days. thereafter. List this matter on 5th September. Copy of this order be communicated to the court below as well as the district judge forthwith. Yes. Interim order to continue. Experience not say problem. There is one approach. If you do not know, you, and particularly when there's a communication from the High Court, what we do is, even at this stage of becoming senior district judges, we used to ask others. Again, so you ask others, take the experience of others, then you submit something in writing. Anyway.
ଖାଲି ରିକ୍ୱେଷ୍ଟ ବି କରିଦେଇଥାନ୍ତେ ଆଉ ଟିକେ ଟାଇମ
ଟାଇମ ଟି ବଦଲେଲେ ସରି ଦେଇଥାନ୍ତା। ମୁଁ ପଠେଇଛି, ମୁଁ ଶିରସ୍ତା ଦାରକୁ ଡାଇରେକ୍ସନ ଦେଇଛି, ସିଏ ଆଣିଲେ ମୁଁ ତାପରେ ରିପୋର୍ଟ ଦେବି। ୟେସ୍ ଆଉ ନାଇଁ ଆଉ ହେଇଗଲାଣି ଥାଉ। ଆଉ କେତେଟା ଅଛି?
32 ଟା ଆଜ୍ଞା infructuous ହେଇଯାଇଛି।
32 dismissed as infructuous। ସରିଲା ତ? ଆଉ ତିନିଟା ଅଛି, ଆସିଲେ ଦେଖିବା।
Grateful.
To 7 arises out of one FIR. And previously, my lord, your lordship granted bail in the main case, my lord, that is 10686 of 2020. In that case, my lord, 4-month bail was granted. And in this case also, my lord, interim order was extended. But unfortunately, my lord, in 8127, wrong order was typed out as 9510. And in 9510, my lord, inadvertently, the order data has not been mentioned. That's why I filed fresh application, my lord. Fresh I have to file to extend the interim order.
I still don't understand. 8127 last order by Justice Aditya Mahapatra. According to our brief.
Yes,
did you see that?
Yes, my lord. And
thereafter there no order has been passed.
Yes, my lord. That is, I am saying that on last occasion, your lordship.
So that order which you say has been passed in 9150 should have been passed in this case.
Yes, ma'am.
Is that what you are saying?
In both the case, my lord. Both the case, interim order has to be extended, my lord.
There was an order, actually a joint order, but jointly the matter was heard jointly.
Yes, jointly heard. And in the main case, my lord, interim order is going to be expired. Interim order is continued till 25 October 2024.
No, now what do you want actually?
In the present, I have filed the present fresh application, my lord, fresh IA. That has to be continue till the main case is expired. Because in the main case, my lord, interim order is to 25/10/2024.
It was still 6/9/2024.
Yes, ma'am.
6/9, not 25/10.
But they have released after some days, my lord. Some days passing after the order, my lord.
Anyway, I've said that the interim bail granted is extended till 6/9.
Yes, ma'am.
So beyond 6/9 you cannot stay.
Ma'am.
That is the order passed in the main case.
Yes,
Now
ma'am.
you want an extension?
No, yeah, in the original, my lord, 4-month order was passed, my lord. On that day, my lord, wrongly submission, my lord.
I'm still unable to understand.
Wrongly told that dates are 9/6. Actually, the year was released on 25/6/24. So it will be extended till 25/10. 4 months. But they hurriedly wrongly submitted that.
The BLAPL number
last of-
9510. In this 9510 also you have filed an application for
Yes, my
extension.
lord, in both the bail applications.
9510 lekhantu. By order dated 15/5/2024. Passed in BLAPL number 9510 of 2023 and 8127 of 2023. Interim bail was granted to the petitioners for a period of 4 weeks. Subsequently, by order dated 6/7/2024, passed in BLAPL number 9510 of 2023, it was extended till 6/9/2024 on the submission of the counsel for the petitioners that the 4 months period is due to expire. 4 months period of interim bail granted in 2 other applications, namely BLAPL number 10686 of 2022 and 9032 of 2023 is due to expire on 6th September 2024. So, it is submitted that such submission was inadvertently made without referring to the actual date of release of the petitioners. As such, the 4-month period is due to expire on 25/10/2024, and therefore the interim bail extended by order dated 16/7/2024 till 6/9/2024 should be further extended till 25/10/2024. Stop. Learned, who's appearing for the other side? Patro.
I've already informed him. He has also intimated me.
No, he's not there. So, considering the submissions, the interim bail granted and extended earlier is further extended till 25/10/2024. A case rehla. Sara case re similar order pass
Similar.
karna.
8127 also.
Sara case re be similar order pass. Yes.
Item 37.
None appears. Place this matter when moved.
Item 38.
May I please? This is a case where the informant initially got admitted in A&M, but it has been alleged in the affair that instead of she will be adjusted at Baripada, she has been admitted in the A&M.
This is quashing.
Quashing fine. And in the meantime, your lordship directed, I have already refunded that money. And the informant come forward saying so that I have no objection. If there is no allegation that I have cheated.
Is it a compoundable? Is it a compoundable matter?
Like compoundable?
No. Issue notice.
Issue notice.
What interim order do you want? No course.
No course of action. Till today, I don't know that. But I have annexed that page 21. Onita saw 50,000. She has received that amount. Se kouchi mate Baripada admission daba badale mate Noyagadre admission de dele. That much allegation.
All right.
ଆମ ଅଜ୍ଞାତସାରେ ତାଙ୍କ ଇଚ୍ଛାରେ ନୟାଗଡ଼ କୁନ୍ତଳା ଦେବୀ ନର୍ସିଂ ଟ୍ରେନିଂ ସ୍କୁଲରେ ଆଡମିସନ କରାଇଛନ୍ତି।
All right, issue notice to the opposite party number 2
Well,
by registered post with AD returnable within 4 weeks. Requisites be filed within 3 working days. List this matter
24th October.
24th October. IA. No course of action shall be taken against the petitioner till the next day.
obliged.
The case diary ଦରକାର ହବ ଏଥିରେ?
Yes, letter appear and say,
No, I'm just
Already-
simply issuing notice.
yes, my lord.
Thereafter we'll direct her to appear.
Yes.
If had been next.
Yes.
Obliged.
Petitioner advocate will ensure her appearance.
ତାପରେ ସେଟା ଗୋଟେ ଡେଟ୍ ପରେ କରିବ।
ଆଜ୍ଞା।
ୱିକଲି ସେଟା ସରିଗଲା ବନ୍ଦ କର ୱିକଲି ଆରମ୍ଭ କର। କେତେ? Item number? Yes, item 2.
List item number. Yes. But there have been development before the Hon'Ble Coordinate Bench, which will dispose of if I take the instruction pursuant to the direction of the Honorable Judge. The order dated 10/5/2022, your lordship may kindly see. The encroachment was there over some private property by the government college.
10/5, yes.
Your lordship got it. This matter is taken up the Mr. G.N. Raut, Additional Standing Counsel, placing the facts and circumstances of the case as those emanate from the rival pleadings and in course of further hearing as to the merit of the appeal which has been filed against the confirming judgments of the courts below, praised for grant of some time to make an endeavor upon discussion with the authorities of the state for resolution of the dispute giving rise to the suit by way of payment of compensation to the respondents plaintiffs for the land which is in constructive occupation of the defendant DDA College in terms of the provisions of the Land Acquisition Act 1894, as if notification under 4(1) of the Act was published on the date of institution of the suit on 14/2/2003. So thereafter, what has happened, that instruction, if I place before lordship, then I think the matter can be settled here in the second appeal.
Yes.
There have been correspondence for the ultimate present status of the acquisition of the land. If there is admittedly encroachment, then this has to be compensated. That will compound the whole thing.
Yeah, but that is the order which was passed by the coordinate bench.
Yes.
Now, what do you want now?
Your lordship may give me some time. Let me ascertain as to which the compensation has been determined and paid.
All right. Sri A.R. Das, Leonard AG, referring to order dated 10/5/2022, passed by this court, wants to take instructions as to if any compensation was paid or has been paid.
Determined and paid.
Has been determined and paid to the respondent plaintiffs for the land in the constructive occupation of the college. List this matter. कर दीजिए.
September 7.
In the
26 September.
in the week commencing 26 September.
Sir, Hon'Ble.
So item number 7.
And then for the respondents also.
Nobody is appearing. Mr. Manos Chand is not
Chand
appearing.
is appearing, my lord. Mr. Chand is appearing, my lord.
Yes.
Now one pass over, my lord. He's on the way, my lord.
All right, pass over. You call him, better call him quickly because there is
He's on the way. my lord.
he is here. Yes, Mr. Chand, what could be the offense here?
But it's a civil offense, my lord.
Civil offense?
My lord.
All right.
Because the SC/ST person, he has been
Very good to see you moving a second appeal.
2018, my lord.
So what? I am seeing it for the first time. In 2018, I was elsewhere, somewhere else. I was pushing files. Yes.
But delay is there.
Delay conduct ହେଇନି ପର୍ଯ୍ୟନ୍ତ?
No,
Notice ହେଇଥିଲା? Who is appearing?
I am appearing.
କେତେ delay?
100 some odd days, my lord.
100 କେତେ days?
100 not 2 years ଥିବ.
100
497 days delay?
It was 2016 to 2018.
495 days delay. What is the matter? Tell me. If there is any substantial question, then only I will.
Substantial question is there. Here, my lord, admittedly, although I am not because of the fact delay, the fact, my lord, like this. The present appellant, my lord, she is the adopted daughter of a scheduled tribe lady. And with that capacity, my lord, she is entitled for the benefits of her mother. But all the same, my lord, it has not been because of the fact that her mother expired and she is married to a Christian person. That's why her right had been curtailed, and that is the subject matter of the suit as well as the appeal, man.
So it's against a confirming judgment.
Both the court I have lost.
What was the finding of the trial court?
My lord.
The plaintiff is Mohammed Wahid. Yes. The plaintiff is Mohammed Wahid. Wrong file don't see.
No.
Wrong file.
Lucia CORAM. RSA 107.
You want Mohammed Wahid Baharani?
Mohammed Wahid put a party again.
Mohammed Wahid to go suit
Respondent.
Mohammed Wahid has filed the suit, my lord. So it was allowed.
Who is he?
My lord, he is a out person. By this process, my lord, he is claiming.
You are not a party there?
No, the local party was a party.
नहीं थे मोहम्मद भाई जो जजमेंट मो पाखरे अछि ये कौन
Lucia CORAM is the person who has filed the
very difficult
first appeal.
कौन से कोर्ट में जानपुर
Mohammed Wahid filed the suit. Lucia CORAM was the defendant number 4.
4, well.
Okay.
She preferred first appeal.
Challenging.
So the suit was for?
Suit, my lord, was for right title.
Declaration of
Right
declaration that the order of the defendant number 2 passed in RA number for the declaration of right title interest kola. So the suit was dismissed or decreed?
No, suit was decreed in favor of the
suit.
The suit was decreed in part on contest against respondent number 4, 5 to 10 and expecting the right title interest of the plaintiff and defendant numbers over the suit properties hereby declared and the unregistered sale deed data found to be genuine as the order. So he filed an appeal.
Yes.
You filed an appeal.
Against the I, my lord.
Yes.
What
happened?
There might be see the order. Page 60.
Whether the unregistered deed confers any right title interest to the plaintiff.
17.
There is a finding of fact that you are not the adopted daughter.
No.
The plea of adoption has been negative. So that's a finding of fact. So how do we entertain it?
I'll take it coming Monday. I'll try my best. Monday.
Concurrent finding of fact.
Yes, that is there. Only I'll take it
Monday. Findings. Yes, I'm willing to adjourn it. Next week, but
I will mail that.
You prepare accordingly. Satisfy the court.
Yes.
That is a purely question of facts. And there's a reference to a previous suit where the adoption probably has been decided, and that aspect has never been challenged.
Yes, and in the meantime, my lord, the particular sub-collector by OSD, he has also passed an order wherein declaring the particular things in my paper. I'll set all those in.
All right. Release this matter next week. We commencing 2nd September.
Obliged.
So item number 17.
17 is for hearing or
Instead of next week, 1 week after. No, no, nine.
week commencing 9 September. Item 17.
My lord, item 17, there is a delay of 5 days, my lord.
Delay 5 days.
My lord.
Notice has to go.
No, my lord, my learned senior Mr. L.K. Sahu has appeared.
Your Lordship,
Somebody has appeared.
on behalf of Mr. Nirod Kumar Sahu, we are appearing suo moto, Your Lordship. We have not received the notice.
All right.
We have no objection. The delay may be continued.
All right. Office has pointed out delay of 5 days in filing of the appeal. Considering no notice need be issued as the respondents have already entered appearance suo motu, on whom a copy of the petition has already been served. Have you served? Serve it now, right now.
The delay copy, I will serve right now, my lord.
IA copy has been served, Your Lordship.
Served, okay. On whom a copy of the IA has been served. Considering the grounds raised to explain the delay, as also the fact that the counsel for respondents has no serious objection, I'm inclined to allow the prayer. The delay in filing of the appeal is condoned. Yes, admission.
May I pray for next week, my lord?
Admission.
Your Lordship, a short date maybe.
Yes.
A short date maybe.
Yes.
17th September.
Let's this matter for admission in the week commencing 17th September.
Oh, maybe.
My lord, copy I'm serving right now.
Item number 26.
26 staff hearing it order 41. Item 26. Yes.
For sole respondent, I have already.
Notice ଯାଇଥିଲା?
ନା ଏଟା admission ହେଇନି.
Admission ହେଇଛି? Let us see. Admission ହେଇଯାଇଛି ତ order 41 ରେ କାହିଁକି ଆସିଲା?
Order 41 ଆସିଛି ତ.
No, is admitted on the substantial questions of law as stated in 5B and 5C.
Time ଦିଅନ୍ତୁ ସାର୍, ମୁଁ ଭାବିଛି admission ହେଇନି, ମୋ ଫାଇଲ୍ ପଡେ। ଏଇଟା ସେଇ ଟିକେ October 1st week ଅଛି।
2016 matter, Mr. Mahanti.
September last week ଅଛି। Ready.
What is this matter?
Worship encroachment matter at right title interest
Reversing judgment.
Reversing judgment. We were plaintiff in the trial.
All right, this is admission.
September last week.
All right.
More than admit ହେଇନି।
As requested by Sri Maheshwar Mahanti, learned counsel for the respondent, list this matter in the week commencing 30th September.
So interim order to
Interim order to continue.
Please.
So right now 39.
39, my lord. Big criminal police. 39, my lord. Not the prefer next week, my lord.
Next week as fruitful. 2nd September. Yes.
So right now 45.
Sir, जो भी स्टेक है। पास ओवर कौन करे? ये ना तो कौन करे पास ओवर?
କାଲି ମତେ ଗୋଟେ ପିଟିସନ ଦେଇଥିଲି ଅର୍ଡର 14/27 ରେ ମୁଁ ଆର୍ଗୁମେଣ୍ଟ ରେ କହିଥିଲି ତାର ଅବଜେକ୍ସନ ପକେଇ ଅନସିଲି ଡେରି କରିବା ଦରକାର ନାହିଁ ଆର୍ଗୁମେଣ୍ଟ କଲେ ମୁଁ କହିବି ମୁଁ ଲ୍ୟାଣ୍ଡଲର୍ଡ
The matter is the list is valid till Saturday, so I can only pass it over.
ଆଜ୍ଞା
Pass over for the day. You are the tenant.
ମୁଁ ମାଲିକ
You are the landlord.
ଆଜ୍ଞା
Okay.
ସିଏ କହୁଛନ୍ତି ଯେ ନାଇଁ ଆମେ ତାଙ୍କର କୋସିଆର ଦିଟା କୋର୍ଟରେ ନେଗେଟିଭ 59 ଗୋଟେ ସେକେଣ୍ଡ ଆପିଲ ଡିସାଇଡ୍ ହେଇଥିଲା ସେଥିରେ ସିଏ ଆମ ବଂଶଧର ବୋଲି କିଛି ନାହିଁ
ଦେଖେ
ଆଉ ଏଠି ଗୋଟେ ଅର୍ଡର 14/27 ରେ ଆଉ ଗୋଟେ ଫେବ୍ରିକେଟେଡ ସୁଟ୍ ସେଇଟାରେ ଗୋଟେ ଆଉ ଗୋଟେ ଜେନେରାଲ ଦେଇଛନ୍ତି ବାଇପାସିଂ ଦ 59 ଜେନେରାଲ ଯେ ସେଟାକୁ ଇଏ କରିବାକୁ ତାର ଆକ୍ସନ ଏକ୍ସସ୍ କିଛି ନାହିଁ ମୁଁ ସେ କହିଲି ତାର ଅବଜେକ୍ସନ ଦରକାର ନାହିଁ ଏଟା ଶୁଣିଦେଲେ ହଉଛି
yes ଆଉ ଅଛି
Sir, item number 46.
pass over.
I may be pardoned, my lord. My lord, item 39, interim order to continue.
Item 39 interim order to continue. Item 46 सरला अभी जी नहीं सरला
ସବୁ ତ ଟଚ୍ କରିଛନ୍ତି ସବୁ ତ ଟଚ୍ କରିଛନ୍ତି
ଆଜ୍ଞା
ସବୁ ତ ଟଚ୍ କରିଛନ୍ତି କୋଉଠି
ସବୁ ଟଚ୍ କାଲିଠୁ ସରି ଯାଇଥିଲା
ପଡି ଯାଉଛି